The court will call D1GN 26002511, Texas Hemp Business Council and others versus the Texas Department of State Health Services. Please state your names for the record.
Your Honor, as I said earlier, my name is Jason Snell, and I represent certain of these plaintiffs. I would like to, if I could, we have many lawyers, I'd like to introduce our team based on which plaintiffs we represent, if that's acceptable. Amanda Taylor is to my left, and J.R. Johnson is at the counsel table behind us. Andrea Steele, who is sitting in the gallery. Lance Cawthon, also in the gallery. And again, my name is Jason Snell. Together, those lawyers represent the Texas Hemp Business Council, Alchemy TX Consulting LLC, A to Z Investments and Wholesale, CPRT and Company LLC, and Texas Green Craft LLC. I also would like to mention that at counsel table is Mark Bordas. He's the executive director for the Texas Hemp Business Council. At the counsel table behind me, Andrew Alvarado, and he is the attorney for the Hemp Industry and Farmers of America. David Sergi and Anthony Fusco. Mr. Sergi in the counsel behind us. Mr. Fusco is not here today. And together they represent Elevate One TX LLC, DBA Elevate Wellness Dispensary LLC, Clutch City Gas LLC, DBA Texas High Council, and Salganic Services, Inc.
All right.
Thank you, Your Honor.
Thank you, counsel. All right, so over here on the state side.
Your Honor, Zachary Berg from the Office of the Attorney General. On behalf of all defendants, I'm joined by my colleagues, Allie Thorburn, Jacob Dustin, Stephen Loomis, Jim Rich, and Keith Ingram.
All right, thank you. I will ask, please try to stay seated in your current seats because we have it all in a seating chart, and it will make it easier for me to memorize and remember all of the names. All right, so what we have set for today, I want to briefly go over what's set today and what isn't set today. We have a plea to the jurisdiction that was filed by defendants on April 22nd, 2026. And then we have a plaintiff's application for a temporary injunction after another district judge signed a temporary restraining order on April the 10th, 2026, which the parties extended by an agreed order extending the temporary restraining order that was filed on April 23rd, 2026, and that was pursuant to a Rule 11 that was filed on April 21st, 2026. So as a reminder, I always want to say up front, we are assuming we get through the first part. We're going to go through that issue first. The plea to the jurisdiction should be heard first. I need to deal with that issue first. And then if and when we get to the TI section, the court is going to be looking specifically for a finding in order to be able to get to a TI. And that's, you all should know this, but I just always want to be clear about what we're here for and what we're not. Your role today is to show that there's a cause of action against the defendant, that there's a probable right to the relief sought, and a probable imminent and irreparable injury in the interim. We are not here on the merits of the case, but to determine whether the plaintiffs have met their burden for a temporary injunction to maintain the status quo pending trial. So that's what we're here for this morning and for the next few days. And the next question I have is, I did receive an exhibit list from the defendants. I don't have an exhibit list from the plaintiffs, but I want to know if there's any agreed exhibits at this time that you all want to, that helps expedite the case. If you already looked through the exhibits and you have no objections to any number of exhibits, we can go ahead and offer those, and we can get them on the record now.
Your Honor, if I may approach.
Yes.
We have uploaded the plaintiff's exhibit list with the agreed to exhibits marked, but
Oh, you did. Come on
in the
up.
event that you don't have that,
I didn't have
this
that.
hasn't been marked yet, but we're going to go through that.
Okay.
I can. We have conferred and we've agreed
Okay, wonderful.
on certain exhibits.
Great. I hadn't seen it ahead of time, but that's easy. I now have both pieces of paper in front of me. So let's start with plaintiff. If you already know and you've discussed it, go ahead and offer your exhibits that are not, that you believe are not objected to.
Mr. Berg, may I proceed, and you let me know if you disagree?
Of course.
Okay. Would you prefer that I remain seated or stand for this sort of thing, Judge?
I think for this, stay seated. I want to be able to hear you nice and clearly, and
Okay.
there's a record being taken.
Okay, thank you, Judge. The parties have conferred and agreed on the admission of these exhibits. Plaintiff Exhibit 1, Plaintiff Exhibit 6, Plaintiff Exhibit 7, Plaintiff Exhibit 8, Plaintiff Exhibit 9, Plaintiff Exhibit 10, Plaintiff Exhibit 11, Plaintiff Exhibit 12, Plaintiff Exhibit 13, 14, 15, 16, 17, 18, 19, 21, 22, 23, 24, 25, 26.
All right. Are there any objections to the offer of those exhibits?
No, Your Honor. I believe we also agreed to pre-admit plaintiffs 29.
Okay.
That is a demonstrative that we removed from the exhibit list and put it into the non-evidentiary materials. So while there's an agreement on that, our thought is with respect to our demonstrative exhibits, we do want those marked so they're a part of the record. But my understanding from Your Honor's rules is that you don't want those as exhibits, evidentiary exhibits.
We will mark them as demonstrative exhibits.
Okay.
So, so you can go back into box and just label it as a demonstrative 1.
Okay.
So you just have 1?
We have more than one. We have several, but that's the reason why I mentioned just one is that Mr. Berg mentioned number 29, which was a demonstrative
Okay,
exhibit.
number 1. Are the rest agreed or not? The rest of the demonstratives? Are there any issues, objections to the rest of the demonstratives?
We haven't seen them specifically.
All right.
We address them only as exhibits.
Got
Also, Your Honor, some of the demonstratives were marked as exhibits, and so we would object to them on that basis, but we don't object.
Well,
to
what I just said is we pulled those off the exhibit list. So to the extent they have been marked as exhibits, they no longer are so.
Yeah, understood. Okay, so in terms of plaintiff's exhibits that were just read into the record and offered, does the state have any objection?
No, Your Honor.
Okay, so P1, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 21, 22, 23, 24, 25, and 26 are admitted. Let's go over on the state side, and let's have you offer your exhibits that you believe are uncontested.
Thank you. Excuse me.
And I know there's only one microphone that you all, we're working on getting more microphones, but currently there's only one per council table, so you'll have to share.
Thank you. We believe pre-exhibited, we have defendants exhibits 1, 2, 3, 6, 9, 10, 11, 12, 13, 17, 18, 20, and 25.
Any objections to those?
No, we have no objections, Judge.
All right, D1, 2, 3, 6, 9, 10, 11, 12, 13, 17, 18, and 20, and 25 are admitted. All right. So let's have, Mr. Snell, you're gonna be starting.
Yeah, yes, Judge. As I explained,
Your Honor, if I may, before we go on, there's also an opposed request to record proceedings pending.
Okay. Go ahead, you can present on that.
Yes, Your Honor. Would you like me to stand or sit? It's fine.
You should stand. You can stand in council table.
Yes,
Thank
Your Honor.
you.
Defendants oppose the request to record proceedings. We believe that it would unduly distract participants. We would cite anecdotal evidence. We'd cite a few things. Cameras in the courtroom, which was a hearing before the U.S. Senate Committee on the Judiciary.
I'm sorry, counsel, I'm gonna ask you to slow down if you're reading. Appearing before, go ahead.
The United States Senate Committee on the Judiciary, 64% of participating federal judges found that cameras made witnesses more nervous. I'd also cite a study from the Journal of Law and Empirical Analysis, Performative Judging, Measuring the Effects of Video Recording on Judicial Behavior, which was a study of the Federal Ninth Circuit Court of Appeals. The study found that the judges speak more and more likely to interrupt attorneys when proceedings are video recorded. The study found that the size of the effect varied depending in part on the race and gender of the attorney. I would also cite to a article from the Journal of Media Critiques, a 2017 survey of 208 California state judges. The survey found a tendency for some participants to behave differently when cameras are present and creating inaccurate impressions about the judicial system among the public as a result of not providing sufficient context for what is reported. For these reasons and for the reason that defendants do not consent, we would oppose the motion and ask the court to refuse it.
All right, any response?
Jim Hempel. I'm not sure if the attorney for KUT is present, Mr. Hempel, but we believe that the proceedings should be broadcast. We did 4 years of YouTube hearings, including trials that were broadcast, well, not on YouTube, Zoom, but also broadcast on YouTube with no disruption. I don't think anyone had a problem. I don't see any of the members of the press causing trouble in here. I don't think it's going to be any different than if they weren't in here, as far as the decorum of the courtroom and the nervousness of witness. Everybody knows the stakes. So we hope that you grant the motion and let the world, or whoever wants to know what's going on, see what's going on. But this is an important case, as we all know. So let's let everybody tune in.
All right, so this is the court's ruling on that subject. The court's ruling is the following. The state and federal Supreme Courts have held that a trial is a public event. What transpires in a courtroom is public property, and a trial proceeding is public information. This particular hearing, which is the plea to the jurisdiction, but also the application for a temporary injunction, is concerning matters subject to the state's food and drug health regulations. And that is no less of a public event of substantial public interest than a trial on the merits. There is no special right or privilege that enables the court to suppress, edit, or censor events that may come to life in proceedings before it. To disallow a media request to record this public event, a request that follows the guidelines promulgated by the Texas Supreme Court for civil cases and satisfies our local rule, we have a local rule on this, that's 16.4, would be equivalent to conducting this hearing in private, closing the court to spectators and news reporters, and thus denying the public its right of access to public information, what this court will not do. The purpose of Article 1, specifically Section 8 of the Texas Constitution, is to preserve what we call liberty of speech and freedom of the press. The court is implementing our Constitution's guarantee of public access to civil procedures, the freedom of speech, and the freedom of the press. And the Texas Rules of Civil Procedure that I'm quoting are 18C, our local rule 16.4, and the Texas Supreme Court's guidance governing the recording and the broadcasting of court proceedings. And so that motion is granted and your request is denied. Let's move forward with the plea to the jurisdiction.
Your Honor, if I may, the parties have agreed to this order of business, subject to Your Honor's agreement, of course. We're hoping to proceed that the parties give brief opening statements, just to give an overview of the case. Post that, the state will then present its plea to the jurisdiction. We'll respond to that and then move into the evidence, if that's acceptable to Your Honor.
That's acceptable.
Thank you, Your
All
Honor.
right, let's move forward.
And with respect to the presentation of the opening statements, would you prefer that we be at council table or at the podium, or do you have a preference?
For the opening statements, whatever you prefer. You can use the podium if you're more comfortable for opening, or you can stay in council table. Doesn't matter to the court.
Okay, and for opening statement, Miss Amanda Taylor will handle that on behalf of
Okay,
plaintiffs.
she may come to the podium or be at council table.
Okay. And we do have a PowerPoint. I don't know how to connect it, but it is connected. I don't know how to make
Ms.
it.
Gutierrez, do you have to do something with our controls? If she's sharing it, are you sharing it already? Have you pushed the gray little button to get to?
That's a great question.
There's a little gray button. It's a little hidden, but it's there. You have to push and hold it
There we
for a
go.
second or so.
I pushed it, yeah.
Okay.
Ms. Taylor, would you make sure that microphone is on? It should have a green light.
Should be a bright green light.
Yes, Your Honor, it has a green light.
Got it.
Can you hear
Okay.
me okay from here?
So there's your presentation, and we're ready. Go ahead, Ms. Taylor.
Good morning, Your Honor. The plaintiffs are here today seeking a temporary injunction, seeking to enjoin defendants from enforcing a set of new administrative rules that were enacted to be effective March 31st of 2026, regulating the commercial side of Texas's consumable hemp industry. The plaintiffs are 7 Texas businesses who are licensed and registered growers, manufacturers, distributors, retailers, and processors of hemp products, along with 2 trade associations in this industry. These plaintiffs are representative of the industry as a whole, Your Honor, which faces significant supply chain disruption, and honestly, they risk a complete shutdown of their businesses if these rules are not enjoined. As the court mentioned 2 weeks ago, Judge Maya Guerra-Gamble considered the merits of the plaintiff's claims and concluded that without a restraining order, there would be immediate harm. She granted that TRO, which was extended, and now we respectfully request that the court extend the protection of this industry by granting a temporary injunction. Before I dive into the merits, I'd like to give the court a little context about what this case is and is not about. First, this case is decidedly a separation of powers case. We have a situation where the state defendants, the administrative officials, have overreached their delegated rulemaking authority into the territory of the legislature. Since 2019, we have had a comprehensive framework of statutes that govern the consumable hemp industry. And in 7 years, our legislature has considered multiple amendments. Importantly, Your Honor, they have not passed a single change governing the commercial side of this industry in 7 years. These are matters of legislative discretion that the agencies have now attempted to do themselves. We ask the court to enjoin that improper conduct. This case is also about, as I mentioned, the disruption of a regulated industry with detrimental impacts on the Texas economy. Texas prides itself on being a business-friendly state, Your Honor. And the consumable hemp industry over 7 years has developed in reliance on the framework enacted by our legislature in 2019. Far from being the Wild West, this is a highly regulated industry, and it has been performing very well for our state. You are going to hear evidence that there has been, in 2025 alone, a $11 billion positive impact on our state's economy from this industry. And that is because these products are widely used by consumers, including many veterans. You're going to hear from the veterans in this case about how these products provide natural alternatives to alcohol and chemical drugs. They help veterans with PTSD, anxiety, sleep disorders, and similar things like chronic pain. This is an important industry for the state, both for the consumers and the economy. The challenged rules that we're going to talk about over the next few days would disrupt this industry. It would also result in a lack of safety if these consumers then turn to alternatives like black market products or things from out of state that can't be regulated by our agencies. The simplest way I can think of this, Your Honor, is what the new rules do to the Texas hemp industry would be like trying to regulate Texas's wine industry by banning grapes. And we all know that would be an absurd result, and so are these rules. Okay, so what is this case not about? This is equally important. This case is not about policy choices regarding the legality of hemp. That is a matter for the legislature. It is not a matter for the agencies, and it's not a matter for this court. We don't ask you to make any policy decision on whether or not consumable hemp products should or should not be manufactured and sold in this state. This case is also not about consumer safety. In 2026, at the direction of Governor Abbott, the agencies also passed a handful of new consumer safety protection regulations. And the plaintiffs do not challenge those regulations. In fact, our clients supported the enactment of those regulations over the course of many legislative sessions and in this rulemaking process. You might have heard about these on the news. There are things like what we call age gating, so that people under 21 can't buy the products, increased recall and complaint procedures, enhanced packaging with warning labels and electronic links so that consumers can see exactly what's in the products, and additional authority of the agency to inspect. Again, we support all of those consumer safety regulations, and nothing about the injunction that we request from this court would prevent those from being enforced. Okay, so turning to the temporary injunction that we seek. As Your Honor already acknowledged, there are three essential elements: a probable right to relief, immediate harm, and no adequate remedy at law. We can satisfy all three of those easily, and the evidence you're going to hear will support that. I have given the court at demonstrative 1 in your notebook a one-page chart that serves as somewhat of a roadmap for all the claims and the elements that I hope will orient the court as we go through the evidence that you're going to hear in the next few days.
Let me stop you for just a moment.
Sure.
I think there's a binder that is for me. You may approach.
Yes.
And if the state has anything in paper that you wish to give me, I'm very good with electronic, but if you have something you want me to physically have, I will take it when it's your turn. Okay.
Thank you, Your Honor.
Go ahead.
So as I mentioned, at demonstrative 1, there is a one-page chart that will provide a roadmap of these multiple claims. As you can see, we have 4 categories of challenged rules that we challenge through 3 separate causes of action. The first causes of action, the ultra vires and the APA violations, those attack all 4 categories of the rules. So this court is being asked to enjoin all of the rules based on the fact that they are both ultra vires and violate the APA. Additionally, we have constitutional claims. Those are aimed only at the third and fourth categories, imposing fees and penalties. Starting with the ultra vires claims, Your Honor, the legal standard agreed upon by the parties here is that rules enacted without delegated authority or that are in conflict with the governing laws are ultra vires. They exceed that authority, and they are invalid on that basis and should be enjoined. So in order to determine if a rule is ultra vires, you have to look at 2 things. 1, what is the rulemaking authority? And 2, what are the governing laws that we say are in conflict? So here, section 443.051 is the clear delegation of rulemaking authority. And what it requires is that any rules enacted by HHSC on behalf of dishes for the consumable hemp program must be consistent with a body of governing law. The good news is the parties agree on what that body of law is. It includes the 2018 Farm Bill, the USDA regulations implementing that bill, the 2020 hemp plan approved for the state of Texas, and the 2019 Farm Bill incorporated into that plan. So we agree, these are the governing laws that any rules must be consistent with. What we disagree about, and what will be up for this court to decide, is whether or not the rules conflict with the governing laws. It is important to remember, Your Honor, when you make that decision, that in 2025, our legislature expressly said Agencies are not entitled to deference in interpreting the statutes or their own rules. That is now expressly part of the government code that will shape your ruling in this case. They do not get deference for how they interpret the statutes or the rules. This court independently makes that determination. So moving to the first category of the challenged rules. Now this is a mouthful. I'm going to try to break it down. The first category are rules that implement a newly prohibitive THC compliance standard. It's more restrictive than the statutes, and it's imposed through a new testing mechanism that we're going to talk about. So as I said, you start with the governing laws in order to determine if the rules conflict. So the big intro to the governing laws is the 2018 Farm Bill. The 2018 Farm Bill did two very important things, Your Honor. First, it legalized hemp. It removed hemp and THC in hemp from the list of controlled substances. It defined hemp by its actual Delta-9 THC concentration. You're going to hear a lot about the actual Delta-9 THC. That is the federal Farm Bill's governing definition. And it expressly protected the right for interstate commerce, interstate transport of these products. Three important things under the Farm Bill. Secondly, it separated the agricultural sector from the commercial sector. This is also something you're going to hear about day in and day out through this proceeding, because the separation of the agricultural from the commercial is absolutely critical to understand why these rules are in excess of the agency's authority. So under the Farm Bill, on the agricultural side, the USDA governs plants, crops in the field at the plant level. Separately, the FDA has authority over the commercial side. But the FDA chose to not implement a commercial hemp program at the federal level. Instead, they left that to the states. A state can enact its own commercial program. And that's exactly what Texas did in 2019. Texas implemented a comprehensive program, what we call from seed to sale, from the farm to the marketplace, starting with the same division of two sectors, agricultural versus commercial. On the agricultural side, we have the Texas Department of Agriculture. And these plants and their cultivation and production are governed by Chapter 122 of the Agriculture Code. Under that side of the house, the Texas Department of Agriculture had a plan approved, just like the Farm Bill provides. And so Commissioner Sid Miller was very instrumental in getting this plan through and approved by the USDA. Separately, the legislature enacted the commercial side, the regulations that are impacted by this case. This is under Chapter 443 of the Health and Safety Code. It's regulated by DSHS and HHSC. So whereas we have plants on the agricultural side, on the commercial side we have products. We have manufacturing, processing, distributing, and retail sale at the product level. Now the crux of this ultra vires claim is that there are different THC compliance standards and different testing methodologies for each of the two sides. Agricultural has one set, commercial has another set. The rules, as a preview, try to collapse those two things together, and that is the problem. That's what causes the complete market shutdown. So first, in the field, that's where we start at the agricultural level. The grower has to do what's called a pre-harvest test, and at that stage, when you're looking at the plant, scientifically, and this is our expert, we have a chemist who's going to explain this. I'm going to try to do a high-level version of chemistry. But the plant has something in it called THCA. That is an acid that is a precursor to THC. It's non-psychoactive. It is simply a natural acid in the plant. But it's a precursor. I kind of think of like future damages, but it is something that is not THC, it's THCA, but when you apply heat, like sunshine or light and heat, it will convert into THCA. So when you have a plant pre-harvest, you test it for the combined total of the THCA and the THC so that you can estimate on a forward-looking basis, how much THC will there be at the end of the harvest? Because the plant is going to mature when it's in the field. That makes perfect agricultural sense. You test it pre-harvest so that you know at the end of the harvest, what will the total THC be? And then you classify that crop at the plant level as hemp versus marijuana based on the THC concentration. If it passes the test at that stage, then it can enter the stream of commerce. So that's where we come to next. The grower or the farmer hands the plant off to the commercial side, the manufacturer or the processor. Our legislature determined at that critical handoff stage that the commercial actors are entitled to rely on that pre-harvest test. The grower provides it to the manufacturer or processor. They can rely on it. They don't have to test the plant or the intermediate products again at that stage. Instead, they move forward with their manufacturing and processing and distributing. At this stage, the agency can require a test for additional cannabinoids, but that test is not required, and it does not prevent any production or processing. You can test for it, but there's nothing in the statute that the legislature decided at that point there would be a full stop to anything in the process. Instead, you take the plant, you do the manufacturing and the processing steps, you can distribute, which means wholesale, and you can retail sell to consumers. On the commercial side, the ultimate compliance standard is the actual Delta-9, not the converted, forward-looking estimate of what we're going to project at some later date. That doesn't make any sense on the commercial side, Your Honor, because the estimate has already run its course in the field. Now we have a finished product. And for consumers, what we need to do is confirm actual Delta-9 in the finished product and a full panel test to make sure there's no pesticides, harmful microorganisms, things like that. So we are testing for consumer safety, but you are not at the finished product stage estimating some future converted THC. That's not what the federal system does, and it's not what the Texas legislature did. This kind of summarized what we just talked about. Our legislature knew how to implement THC compliance standards and testing methodologies, and they did so at the front end under the Agriculture Code, none in the intermediate stage, and then at the back end, there's the ultimate product compliance test. That is the governing framework that has worked well and has allowed this industry to thrive for 7 years. The agencies now want to take this agricultural compliance and testing and bump it to the back end. That is what will prevent the manufacturing and processing. So we have very clear, we talked about what are the governing laws that these rules conflict with. They are consistent. It's 2 sectors, 2 standards, regulated by 2 agencies. And that is true at the state and federal level. The legislative history is also very important because, as I said, these are matters of legislative discretion, not for the agencies and not for the courts. It is undeniable that through multiple sessions, our legislature has debated and considered whether to amend the THC compliance or testing standards at the commercial level. And not once have they amended that statute. In 2025, we saw SB 3. There was a lot of public attention on this. The Senate, the legislature passed SB 3, and Governor Abbott vetoed it. He realized the ban would cause massive economic disruption in the state and that it suffered from other legal problems, and he said no. He listened to the constituents, an overwhelming majority, including a lot of conservative constituents who said these products serve a valuable purpose and they support our economy. We don't want to ban them. So he called 2 special sessions with the direction to consider further legislation on hemp. Again, the legislature did not pass any amendments. And so then Governor Abbott said, in lieu of any legislative change, I want the agency to focus on consumer product safety and regulate what is within their discretion. Again, we don't challenge those regulations. But the agencies decided to step out ahead and go further than they have authority to do. They tried to do what the legislature could not do by amending these rules in a manner that essentially bans the products. So here you see the summary of the rules that we challenge. You're going to hear through the course of this proceeding the detail. I'm not going to go into it right now, but these are the set of rules in the first category that implement a new, more restrictive THC compliance standard and new testing methodologies on the commercial side. It is important to understand that the agencies also recognized this is a matter of legislative discretion. In the rulemaking record, they said a change to the statute requires legislative action and hence is outside the scope of their review. Yet they did it anyway, and that is why we are here seeking an injunction. So the real world impact of this, as I've said, is a supply chain disruption, a shutdown of the manufacturing process that will not allow these products to be manufactured or processed in Texas. It's going to force all that out of state, and it's not going to allow these products to be on the shelves. And just think of a real world example. Consider a bath bomb or an ointment that has a full spectrum of THC, including THCA. These products are for wellness, Your Honor. They're not going to get anybody high. This is something people use to relax at the end of the day or help with muscle pain. But because it has that acid in it, that THCA, if you apply this decarboxylized conversion test at the end and you heat that acid up, it's going to make the product non-compliant. You have a product that is perfectly lawful under the governing statutes that our legislature enacted, and under these rules, under some Frankenstein test that looks at future THCA in a product that would never actually increase under those real world circumstances, suddenly the product is non-compliant and off the shelves. We've talked about the industry shutdown. You're going to hear from witnesses, Your Honor, who are actual business owners who are suffering from the impacts of these rules right away. You're going to hear their stories. You're going to understand in the real world why these rules are causing such disruption. As I've mentioned, we challenge 3 additional categories of claims. I'm going to go through these relatively quickly for time, but essentially there are interstate transport bans that are in conflict with the express protection of interstate transport under the statute. We have dramatically increased fees, Your Honor. When I say dramatic, we're talking 3,000% and more. Fees that went from $250 to $10,000. These are draconian when applied to a small business. And importantly, the fees are per location. So if you have a retailer with more than one store, they're paying these drastically increased fees at every single location. We also have new rules that impose daily compounding penalties without any procedural due process protections. We challenge those as both ultra vires and constitutional violations in addition to the APA violations. The APA claims, Your Honor, are not even responded to by the state. There are several provisions within the APA, mandatory procedural compliance provisions, that the agencies just simply did not comply with. They have to do a local employment impact statement. They have to give a reasoned explanation of less burdensome alternatives. And they have to give a reasoned response to the comments. They didn't do any of those things. The rules are simply facially invalid because they were not enacted in procedural compliance with the APA. And this last one I really think is worth noting because in the rulemaking process, we had hundreds, you'll hear evidence about this, but hundreds, if not thousands of Texans show up and let their voices be heard. They raised significant concerns with the rules. They raised the same exact concerns we're bringing to this court today. And the agency dismissed them with a conclusory comment that it simply disagreed and wouldn't amend the rules. So they were given an opportunity, Your Honor. They were told how disruptive and wrongful these rules were, and they passed them anyway without giving a reasoned explanation to the citizens of Texas. Finally, we have the constitutional claims. I'll go over these at a high level. They challenge that the fees are an unconstitutional occupation tax that the agency does not have constitutional authority to enact. They challenge that the escalating penalties with no procedural due process violates our due course of law provision, and that the penalty in such a compounding and escalating fashion results in an excessive fine that violates the Texas Constitution. We've already spoken a lot about the harm that the industry faces, but the state at every turn seems to say, well, nothing has actually happened yet. There's been no real enforcement yet. There's no harm. That's not true, Your Honor. That's flatly wrong. On the day these rules became effective, on March 31st, 2026, every Texas business in this industry had to make an immediate choice. No good choice, a Hobson's choice. They had to say, am I going to immediately comply with what my regulating agencies tell me I have to do? Am I going to change my process? Am I going to pull the products from the shelves? Am I going to lay off employees because I can't sell these anymore? All of the immediate harms go into effect as soon as they are required to comply with the law. They don't have a real choice to say, you know what, I'm not gonna comply. And I'm gonna wait and see if you come embargo my products or penalize me in a compounding manner on every single day for violation. So the harm is real, and it happened the minute the rules took effect. That's why Judge Gamble granted the TRO, and it's why we ask you to extend the injunctive relief through the final trial. We've talked about the market-wide disruption that's caused by the supply chain, and this is important for the balancing of equities, Your Honor, because you have to look at this on a broader scale. You have the named plaintiffs in front of you who do represent the entire industry. And what that shows is the public harm for Texas businesses and the Texas economy and the public itself. I'm sorry, I'm gonna move through some of these a little faster. But I want to end here with the balance of equities, Your Honor, because we are seeking an injunction that protects this industry and its consumers. And if there is not an injunction, we are going to have safety concerns because the manufacturing and process will be pushed out of state. Consumers are going to turn to products that our agencies don't have any regulatory control over, whether they come from another state or the black market. The businesses are going to significantly have economic impacts, laid off employees, and the state will miss out on the $11+ billion revenue stream that comes from this industry on an annual basis, which is harmful to the public. So when you consider the balance of equities, Your Honor, we believe the decision is clear and that the court should grant the injunction requested. Thank you.
All right, thank you. You may be seated. I do want to make a statement with regards to people in the courtroom that may have personal cell phones. You are not allowed to take audio or video recordings or take photographs on your personal cell phones. The media that is present here today obtained prior authorization under our local rules and under the rules to be able to record. So if you are in the audience, you should not be pulling out your cell phone, taking photos, taking videos, or audio recordings. If my deputy sees you seeing that, you will be asked to exit the courtroom. So I hope everybody understands the rules. There are procedures in place for how to do that, how to request that permission, and this court has considered that with very specific guidelines. All right, let's go ahead and move forward. And this is Mr. Byrd.
Thank you, Your Honor. At the center of this case is a dispute over how we calculate THC in hemp products, total THC versus Delta-9 THC. My friend on the other side covered that a little bit, so I won't go too far in, but total THC is Delta-9 THC. 1 second, Your Honor.
Sure.
Total THC is Delta-9 THC plus THCA
You have a presentation as well, right?
for the PTJ.
Got it. Okay, go ahead.
This is just my wonderful voice.
All right.
So THC and THC are both cannabinoids, as covered. They come from the cannabis plant. THCA, in its natural state, when it's not being heated, and unlike Delta-9 THC, is not known for being psychoactive or intoxicating. The definition of total THC used in the rules is consistent with the federal definition and consistent with the definition of other states, such as Colorado. This definition is the scientific gold standard used by the labs the plaintiffs hire to test their own products, and it is consistent with Texas's current state hemp plan, which was submitted to and approved by the United States Department of Agriculture in 2020. The concern of dishes and the concern of the governor, who is not a party but who issued an executive order prompting dishes to take action, is as follows. When heated, THCA converts to Delta-9 THC. THCA converts at a rate of approximately 87.7% into Delta-9. These rules target consumable hemp products where THCA has been added to raise the level of a product's Delta-9 THC when heated. A common scenario is where THCA has been synthesized and added in large amounts to products which are designed to be heated, such as vapes, baked goods, or pre-rolls, which are cannabis joints which have been pre-rolled by the manufacturer. When these goods are used in the manner intended by the manufacturer, it is not uncommon for the user to consume a cannabis product that now contains 100 times the legal amount of Delta-9 THC. Plaintiffs touched briefly on SB3. This is not SB3. We'll get into that as our time together continues. Plaintiffs have argued that many people who are consuming these products do so to treat medical conditions. The most recent legislature acted to address that concern with HB 46, which was signed by Governor Abbott. HB 46 expanded the Texas Compassionate Use Program to allow patients to access medical quality cannabis products to treat a wide spectrum of medical conditions. HB 46 added to the list of diagnoses that qualify for the Compassionate Use Program chronic pain conditions, traumatic brain injury, Crohn's disease or other inflammatory bowel diseases, and patients with terminal illnesses or conditions for which they're receiving hospice or palliative care. The conditions which are already covered under a compassionate use program include cancer, MS, neurodegenerative disease, epilepsy, and other seizure disorders, among other covered conditions. Texas has made provision for those that need cannabis products for medical conditions, and I think we can agree that if people are using medical products to treat a medical condition, it would be best that they do so under trained medical supervision. The truth, however, is that many people are consuming these products recreationally, and not just adults. And Texas is allowed to use its police powers to enact laws and regulations protecting public health, safety, and the general welfare. My friend on the other side made the analogy that this is banning grapes to prevent wine from being abused. I would say that plaintiff's position is that we should treat unfermented grapes like we treat wine, and that we can sell wine and call it grape juice. Plaintiffs also challenge the reasonableness and necessity of fees imposed under the rules. Currently, it takes dishes 6 to 7 years to inspect every hemp business in the state. At that rate, some businesses are inspected once a decade, and there is no rule that sellers of these products be inspected before they are issued a license. The new fees contemplate funding necessary to inspect businesses every other year, which is a vast improvement in Dish's ability to ensure that consumers are being sold safe and legal products. Inspections every year, like Texas requires for manufacturers of food, drugs, and medical devices, would require fees much higher than those currently being challenged. Plaintiffs also complain that under the new rules, each day a violation continues, it constitutes a separate violation for the purposes of administrative penalties. Plaintiffs claim that this is punitive However, this is common in how administrative penalties are structured in Texas. It's how we treat workers' comp violations under the labor code. It's how we handle hospitals who are violating safety codes, and how we handle consumer protection actions for violations of the Deceptive Trade Practices Act. For these reasons and more, this court should ultimately deny plaintiff's request for a temporary injunction. Thank you, Your Honor.
Okay, so at this time, we're at 10:17. Let's move forward with the plea to the jurisdiction.
Your Honor,
Yes.
would you prefer that I approach?
Yes, come on up to the podium. You're a little bit too far away. I'll be able to see you and hear you better.
I do have this PowerPoint up on my computer. Do I need to plug into that?
No, you should be able to, he should be able to push his gray button. There should be a gray button in your counsel table. There you go.
Success.
And I actually have a printout of your presentation as well, so I can follow along here on the bench. And you're welcome to come up to the podium so that I can hear you more clearly.
Thank you, Your Honor. James Rich, on behalf of the state. Your Honor, counsel. May it please the court. Plaintiffs object to the rules adopted by the Health and Human Services, the Commission, and the Department of State Health Services through their executive commissioner and through the commissioner respectively. The subject rules relate to consumable hemp products. Plaintiffs object to the procedure of the rulemaking. They object to the content of the rules and the impact. Defendants plea to the jurisdiction, argue that this court does not have jurisdiction over plaintiff's petition, and that the jurisdictional matters, as Your Honor mentioned earlier, be resolved prior to deciding any other matter. Defendants request that the entire matter be dismissed on the grounds that plaintiffs have not and cannot allege facts sufficient to establish subject matter jurisdiction. Furthermore, if Your Honor deems it necessary to consider jurisdictional evidence, you will conclude that no material question of fact exists to show that the required jurisdictional facts do not exist. Sovereign immunity protects the state, state agencies, and officials from suit and liability, except in very, very limited circumstances. Any waiver of immunity has to be express. It is plaintiff's burden to establish that immunity has been waived and that jurisdiction exists. No such circumstances exist here. Plaintiff's live petition purports to set forth 5 causes of action labeled A through E. I'll start with causes A and E first. They are related. A pertains to an ultra vires claim, and E pertains to claims purportedly under the Administrative Procedures Act. Both, at least in part, focus on the scope of legislatively granted rulemaking authority and whether the agencies stayed within that authority. In short, as you've heard, the contest is whether the rules requiring testing and accounting for THCA, otherwise known as THC acid, when considering a consumable hemp product, is legally compliant. Again, cause A is an attempted ultra vires claim, cause of action that against the head officials of 2 agencies. That cause fails on the pleadings because Texas law is that in order to state such a cause of action, there must be allegations which, if proven, establish that the defendant official's acts or omissions exceed the bounds of his or her granted authority, or the actions complained of must conflict with the law itself. As identified in Texas Health and Safety Code 12.001, broad discretion and authority are granted to these officials to perform their duties which they've been tasked. That discretion and authority starts with the broad grant set forth in that statute in front of you, stating that the executive commissioner has general supervision and control over all matters relating to the health and citizens of the state. And subsection B stating that the executive commissioner shall adopt rules for the performance of each duty imposed by law on the executive commissioner, the department, or the commissioner and file a copy of those rules with the department. Now, I don't have a clicker. May I?
Yes.
Thanks, sir.
It needs to be plugged into your computer.
It might be need to.
Here you go. I'll plug it in your computer for you.
I can run it.
Okay.
Well,
I need you to jump to the very end. Keys, if you would, please. It's slides number 15 and 16. The parties' brief dwell in large part on competing statutory interpretation arguments, boiling down to a canon of construction argument on the one side for the plaintiffs, and an incorporation by reference argument on the other side for the defense. The plaintiffs argue that the agency can't add what the legislature has omitted. The defense contends that the incorporation of other laws results in the requisite agency authority. There is rather a more simple and dispositive solution. Again, if you can get me to slide 15 and 16.
This
Thank
is
you. Texas Health and Safety Code, section 443151. Grants DSHS broad authority to test and regulate consumable hemp products for compounds and any other substance prescribed by the department. So even if THCA might not be a substance permitted to be considered when DSHS is analyzing the Delta-9 THC concentration of a consumable hemp product, DSHS has been expressly granted broad discretion and authority to prescribe, test for other substances other than THC, and to prevent the processing of and sale of products containing any such substances. Plaintiff's petition does not and cannot allege facts which, if proven, would establish that the adopted rules regarding THCA testing metrics exceeded the bounds of the authority or conflict with subsection 443.151 of the Texas Health and Safety Code. In fact, in their petition, plaintiffs seem to concede that the regulation of THCA may be a sound policy if legislative authority existed. Such authority does exist squarely in Texas Health and Safety Code section 443151. That provision dispositively establishes that plaintiffs have not alleged either an ultra vires or a valid APA claim sufficient to trigger a waiver of sovereign immunity when it comes to the claim that the agencies acted outside the scope of their discretion. Now, Your Honor, if the court moves in connection with the plea to the jurisdiction beyond section 443.151, we're going to jump to slide number 2. Then we get into the details of Health and Safety Code section 443051. The authority that is eventually granted under 051 provides the same result. We start with a consumable hemp product is a food, drug, device, or cosmetic under section 443001 that contains hemp or one or more hemp-derived cannabinoids. What that tells us is if these finished products come off the assembly line sitting on the retail store's shelves, they must be hemp as defined by the statutes in order to be legal, in order to fall within the scope of permissible products. Plaintiffs are here trying to tell you that different testing metrics apply at the time of harvest versus at the time of determining whether a substance is hemp once it gets put into a consumable hemp product. The remainder of my slides as we go through reiterate the bulk of defendants' written submission demonstrating that the agency's rulemaking authority with respect to THCA. Again, slide number 2 specifically tells us under the Health and Safety Code with respect to consumable hemp products that hemp has the meaning assigned by section 121.001. Nowhere else, no other definition of hemp has been incorporated into the consumable hemp product statutory scheme. The definition of hemp in section 121.001 in the Agriculture Code contains the exact same testing metric as has now been enacted in the DISH's administrative rules at 25 THC 300. If we jump to slide number 5, please. Again, the concern in the definition is concern in the in statute of 121.001 is the Delta-9 tetrahydrocannabinol concentration. The concentration of Delta-9 THC. And we see in slide 6, the concern under federal law at 7 U.S.C. 1639.01 is the Delta-9 THC concentration. And if we move to slide 7, again, in federal law, we're going to jump to 8, please. I apologize. I apologize, Your Honor. We're going to jump to number 10. Again, in federal regulations, the concern is the Delta-9 concentration. And under federal regulations at 7 CFR Part 990.1, the federal regulations use the term Delta-9 THC and THC as interchangeable. Again, to determine if a substance of hemp, you use, if we jump to number 11, this is where we get into the details. The term THC in the federal regulations specifically prescribes, at the very bottom in bold, is the conversion formula that's adopted into the federal regulations. Total THC equals 0.877 times THCA. There's 2 ways to determine the combination of total THC within the federal regulations. Number 1 is whether you use a chromatograph that is used by using heat, which is gas chromatography. The second is by using a liquid chromatograph, which does not use heat, but then involves the conversion formula. That, again, takes specifically into account both the THC, Delta-9 THC, and that precursor, THCA. Texas's grant of authority to DISHS and HHS specifically says that the rules adopted by DISHS and HHS have to be consistent both with altogether with the Texas Hemp Plan, the federal statutes, and the federal regulations. So the CFR 991 that specifically adopts the exact same formula that DISHS eventually adopted it indicates that DISHS has been consistent and has complied with the authority that was extended to them through 443051. If we jump to slides 15 and 16, please. Oh, I'm sorry. It would be 13 and 15. 13 and 14. These are the administrative code provisions that were adopted by DISHS and HHSC. As you can see in the definition of, we need to get to, I apologize, it's got to be, there it is, total THC. The formula that is in the federal code is exactly the same. And again, for the definition of total THC.
I'm sorry, could you repeat that last sentence?
And again, that is for the definition of total THC, just as it was for in the federal code that the agency was not only authorized but obligated to comply with. together and seamlessly 443051 provides the agencies with the authority at 25 TAC 300 at SEC to exercise that authority that such the plaintiffs have not and cannot allege facts sufficient to trigger a waiver of immunity for either their ultra-virus or APA claims. Now, in connection with Cause E, which is their Administrative Procedures Act argument, plaintiffs continue to contest their legislative authority. I won't dwell on that in connection with the APA claim, but they also take some issue with the procedural steps that the agencies followed in order to get these rules adopted. Agency discretion in its rulemaking process is broad. Among plaintiffs' complaints has to do with the agency's solicitation of comments and their responses to their comments in connection with the notice of proposed rulemaking. Texas Government Code Section 2001.033 only requires, in connection with comments, a summary of the comments received. We're done with the slides, thank you. A summary of the comments received, a summary of the factual basis for the rule, and the reasons why the agency disagrees with the parties' submissions and proposals. Exhibit 1 of plaintiff's first amended petition is a printout of the final adopted administrative rules. There, over 1,400 comments are received. Those are summarized and responses provided. The reasons and fact basis for the rules are described, and the legislatively delegated rulemaking authority is outlined. Texas Government Code Section 2001.035 states that a state agency substantially complies with the requirements of 201033 if the agency's reasoned justification demonstrates in a relatively clear and logical fashion that the rule is a reasonable means to a legitimate objective. I see we're just about out of time for a break, Your Honor. I'm watching the clock. Am I okay to go forward?
Yes, I want you to be able to wrap up your argument so that we can proceed with
Thanks very much.
response.
Importantly, in Texas Government Code 2001.035 is subsection D, a mere technical defect that does not result in prejudice to a person's rights or privileges is not grounds for invalidation of a rule. Here, in their rulemaking process, the agencies substantially complied with notice, comment, and response. And that compliance is demonstrated in the pleadings. There's no reason to go beyond the pleadings to determine that the plaintiffs cannot state a claim sufficient to trigger jurisdiction in connection with that aspect of their Administrative Procedures Act. Plaintiffs also take issue with the way in which the notice of proposed rule handles the local employment impact statement. That's required by 2001.022. The notice of proposed rules that was issued back in December of 2025 states the proposed rules will impact the local economy, but DISHES does not have sufficient data to define the impact. If we get into the details of 2001.022 of the Government Code, it tells us that the agency has substantial discretion in how and what needs to be included in that local economy and local employment impact statement. It says that if the agency determines that a proposed rule may affect a local economy, the agency shall prepare a local employment impact statement for the proposed rule. The impact statement must describe in detail the probable effect of the rule on the employment in each geographic area affected by the rule for each year of the first 5 years. The requirement of a local government impact statement is focused on if the proposed rule will have an impact on a specific geographic area within the state. Here, while DISH's proposed rule did determine that there would be an impact, and they announced that, it could not determine if, where, and how for any specific geographic region. The rules say that if the agency determined the existence of an impact, it must report on the specific areas and the impact reported. The agency should then take into consideration specific factors and may take in consideration other factors. The agency's accomplished what they could given the circumstances and information available. Again, substantial compliance is what's required for the agencies. That is what happened. The rules apply statewide rather than to any specific geographic area. Defendants have substantially complied with that procedural component of the Administrative Procedures Act. While the APA does provide a limited waiver of sovereign immunity, the waiver is only triggered if a justiciable controversy is sufficiently alleged. Here, plaintiff's live pleading and its exhibits establish that defendants have substantially complied with the impact statement rule. Accordingly, plaintiffs have not and cannot, just as with the notice and comment provisions, allege facts sufficient to state a justiciable controversy on that issue. No immunity waiver has been triggered. Plaintiffs also allege what they're described as constitutional claims or constitutional causes of action. They're at sections B, C, and D of the amended petition. I don't have much left, Your Honor. Thank you. To show an immunity waiver and establish that subject matter jurisdiction exists for a valid constitutional violation, plaintiffs' claims must not be facially invalid. For cause B, relating to the amount of the licensing and registration fees, the court need not rely on any external evidence to determine that plaintiffs have failed to allege the facts sufficient to trigger the jurisdiction of the court. On its face, the live petition relies on outdated numbers from the notice of proposed rule as the basis for their complaints about the fee amounts being revenue generated rather than being based on the actual adopted rule. That's at paragraph 81 of plaintiff's first amended petition. Furthermore, plaintiffs rely upon a placeholder memorandum of understanding between TABC and DISHUS rather than any actual estimates of the likely costs of the regulatory and enforcement scheme. Exhibit 23 of the petition shows that they're relying upon this memorandum of understanding that specifically states that DISHUS and TABC were still working to finalize their contract and working to establish a basis for computing the costs to be passed from TABC to DSHS. Accordingly, no weight should be afforded to that memorandum. Thus, you're going to disregard the allegations of paragraph 81, which rely upon numbers from a proposed rule, which was never adopted, and you're going to disregard the memorandum that they used to try to establish costs at Exhibit 23. With that, the live petition presents no facially valid claim regarding the amount of fees being excessive. In the event the court looks past the insufficient allegations and exhibits in the first amended petition, no evidence is required beyond the limited information contained in the declaration of Jimmy Charney plus plaintiff's petition exhibits. As evidenced by the submissions of plaintiff and the declaration of Jimmy Charney, the industry has rapidly expanded since the de minimis fees of 100.
Counsel, I'm going to ask you, you lost me. Start with the declaration.
By the declaration of James Charney, the industry has rapidly expanded since the de minimis fees of $100 and $250 were originally adopted. For just one example, Exhibit 3A of plaintiff's live pleading represents the existence of over 7,500 retail stores. The equipment, staff, technology utilized by the agency must keep up. The new fees account for the expanded number of businesses, the planned and authorized inspections and testing, and a testing frequency focused on Texans' health and safety. Plaintiff's complaint about the amounts of fees should be ruled as facially invalid and is failing to trigger a waiver of sovereign immunity. At Cause C, plaintiffs purport to raise a claim related to the due course of law clause of the Texas Constitution. As outlined in defendant's briefing, engaging in the hemp business is not a right to which the due course clause provides constitutional protection. Dispositively deciding Crown Distributing was that due course violations are not to be raised in this type of action. Finally, Clause D, relating to the claims of excessive fines. Here again, the claim is facially invalid. The court need not look past the fact that every food, drug, device, and cosmetic regulated by the Texas Health and Safety Code has the exact same fines, or fines of up to $25,000 per violation, and that each day that the violation occurs may constitute a new violation. Consumable hemp products are, by statute, food, drug, device, or cosmetic. The administrative penalties in the March 2026 rules are squarely permissible and within the legislatively prescribed code at Texas Health and Safety Code 431021 and 431.054. Plaintiffs also complain that the new rules enacted by the agencies seek to supplant the conciliation, warning, and opportunity to resolve provisions found in Health and Safety Code Chapter 443. That's not true. Rather, the rules, as adopted, work in tandem with those provisions. THCA 300.606 of the new rules specifically says the department must notify a retailer of consumable hemp products of a potential violation and provide the registrant an opportunity to resolve unintentional or negligent violations after being notified by the department. So, plaintiffs' claims about the amounts of and procedures relating to the excessive fines should be ruled as facially invalid and as failing to trigger a waiver of sovereign immunity. The huge grant of authority found, as I pointed out at the beginning, in section 443.151, directing the agencies to prescribe, test for, and prohibit the sale of products showing the presence of and any undefined quantity of any other substance is dispositive of the question of the agency's authority to regulate THCA in consumable hemp products. And as briefed, Health and Safety Code 443051 has provided HHS and DSHS with the express direction and authorization to enact rules consistent with the Texas Hemp Plan, federal statutes, and regulations. Each of those sources of law provide a testing mechanism, a testing matrix that takes in consideration both Delta-9 THC and THCA. The rules adopted by these agencies are absolutely consistent with those sources of law that the agencies have been instructed to be consistent with. The essence of the legislative scheme in Chapter 443 is only to permit into commerce hemp products made from hemp as defined in the Agriculture Code at Chapter 121. The characteristics of hemp and the metrics for testing those characteristics is spelled out in more detail in the Ag Code, administrative rules, and federal regulations. Those are adopted into the Consumable Hemp Product Plan. DSHS did not receive direction from the legislature about how to test, how to incorporate, how to consider what is hemp. Again, they were instructed to incorporate the Agricultural Code's metrics and testing. That's exactly what they did. The legislature's election to omit language directing how DSHS and HHS should act is evidence of intent that the agency is authorized to exercise its discretion. A key purpose of sovereign immunity is to prevent a litigant from trying to use litigation to tell the state how to accomplish the state's intent, and to prevent litigants from attempting to use the court to control state action. That is what plaintiffs are attempting here. Plaintiffs' displeasure with the agency's exercise of its authority is not sufficient to bring this matter within the subject matter jurisdiction of this court. Defendant's plea to the jurisdiction should be granted and plaintiff's petition dismissed with prejudice. Thank you.
All right, thank you, counsel. You may be seated. We're going to take a 15-minute break, and then we will proceed with response from the plaintiffs on the plea to the jurisdiction. You all have a good break. It'll be about 15 minutes.
All right.
Okay, let's go back on the record on D1GN 26-002511. And let's go ahead and hear the response on the plea to the jurisdiction. Ms. Taylor again, coming up.
Thank you, Your Honor. We appreciate your time. I'll try to keep this very brief. In response to the plea to the jurisdiction, Your Honor, I didn't hear a legitimate jurisdictional defect. I heard a merits-based challenge. And this court understands that it's important to hear all of the evidence come in and decide the merits of that case, not dismiss it for jurisdiction on the front end. The only actual jurisdictional word that I heard used was sovereign immunity. So very quickly, I'd like to explain why there is a waiver of sovereign immunity on all three of our claims. First, the APA. Section 2001.038 expressly waives immunity for a APA rule challenge. We have pled a rule challenge, immunity is waived, simple as that. Ultra vires challenges, there is also an express waiver of sovereign immunity when a plaintiff claims that a state official's acts exceed its discretion or conflict with the law. That is exactly what we've pled. For jurisdictional purposes, the court takes as true the plaintiff's pleadings and reads them in favor of the plaintiff. That is confirmed by the Texas Supreme Court in Hensley versus State Commission on Judicial Conduct, 692 Southwest 3rd, 184. That's a 2024 case. So we've got a waiver of sovereign immunity for the APA, a waiver of sovereign immunity for ultra vires claims. The state's argument that they have rulemaking authority does not answer the question of whether they exceeded that rulemaking authority. That's the merits-based question. You've heard my opening statement. I'm going to let the witnesses address it from here because the evidence will support that. On the constitutional claims, again, the law is clear that there is no sovereign immunity to vindicate a constitutional right. The Texas Supreme Court in Klum versus Houston Municipal Employees Pension System, 458 Southwest 3rd, 1, and also the Supreme Court in Patel versus Texas Department of Licensing and Regulation at 469 Southwest 3rd, 69. Both cases expressly hold that when you plead a constitutional claim, a viable constitutional claim, there's no waiver of sovereign immunity. To the extent that the state says, well, they're not valid constitutional claims, as I've said, those are merits questions. On our pleading, taking the facts pled as true and in favor of the plaintiff, we have certainly demonstrated legally valid claims that waive sovereign immunity. I'd like to address briefly the state's argument on the definition of Delta-9 THC, defining hemp under section 121.001 of the Agricultural Code. That is exactly right, Your Honor. In fact, it proves our claims. The legislature defined hemp only by its actual Delta-9 compliance standard. That's it. That's the definition in the federal farm bill. It's the definition in the state farm bill. And section 121 of the Agricultural Code governs both the agricultural sector under chapter 122 and the commercial sector under 443. We're not claiming that the state isn't allowed to test these products or isn't allowed to require testing of these products, but they cannot legislate through rulemaking what the legal compliance standard is. There is a difference between total Delta-9 THC through that conversion formula and actual Delta-9, which is what the legislature defined hemp to be. The state showed you a series of federal regulations claiming that that supports their case. What they did not tell you, Your Honor, is that those are all USDA regulations. As we talked about, the difference in the agricultural and commercial sectors is critically important to this case. The USDA regulations that they point you to expressly say they are limited to production, agriculture. They do not apply in the commercial sector. The USDA says that expressly, so those rules are counter to the state's position. Finally, I'd like to touch on their argument under HB 46. This is the medical marijuana or compassionate use program that they mentioned. It is true that the legislature passed that legislation. But what is also true is at the same time, the legislature did not amend the commercial hemp rules. The legislature made the policy choice that compassionate use medical marijuana and lawful consumable hemp are coexisting and alternative programs. One does not replace the other according to our legislature. That is their policy choice. That is not a choice for this court or for the agencies. And there are reasons why we need both programs. The compassionate use program does not provide the same consumer benefits that the consumable hemp program does. Namely, if you are a veteran and you want to continue exercising your Second Amendment rights, you cannot do that if you sign up for the compassionate use marijuana program, because marijuana is a controlled substance. Also, those products are more limited. There are very few licensees. Consumers do not have the type of access that they have to consumable hemp programs, and it's expensive. Finally, you heard about administrative costs and whether or not these fees are for that purpose versus revenue generating. You're going to hear witness testimony on that, but Your Honor, there is nothing in the actual rulemaking record that supports the state's position. That's all I have substantively in response, but I do want to address, Your Honor, the logistics of the timing of this court's ruling. You have in front of you an application for temporary injunction and a plea to the jurisdiction. The plaintiffs respectfully request that this court will be mindful about ruling on the TI first, and then once that order is signed and entered, secondly, ruling on the plea to the jurisdiction. And that is because the minute the ruling on the plea is signed, even if it's denied, it could defeat this court's jurisdiction if they perfected an immediate interlocutory appeal. So we want to be very candid about not allowing that type of gamesmanship that would deprive the court of jurisdiction to hear the remaining of this proceeding. There was a similar case regarding consumable hemp in 2021, and Judge Soifer in that case did exactly this. She signed the temporary injunction order, had that entered in the record, and about 6 hours later signed the order denying the plea to the jurisdiction. That allows both issues to go up on appeal together and would prevent the state from attempting to immediately file an appeal and shut down this court's jurisdiction. Happy to answer any questions about that, but that is our respectful request to the court.
Thank you. Is there anything else?
That is it, Your Honor.
All right, you may be seated.
Thank you.
Anything further on, I think it was Mr. Rich, correct? Briefly, because
Yes, Your Honor.
timing is going to be an issue for us if we don't move forward.
One point, Your Honor, counsel brought up the fact that the federal provisions referenced in connection with the inclusion of THCA into the calculation for THC were under the USDA. Well, there are no rules under the FDA. There are no Food and Drug Administration rules. Accordingly, the state has room and has discretion to act, and it has direction from the legislature to adopt rules consistent with the federal statutes and federal regulations, which is exactly what these agencies have done. Nothing further, Your Honor.
All right. The court's going to take the plea to the jurisdiction under brief advisement. Let's move forward with the temporary injunction.
Your Honor, I believe at this time we're prepared to call our first witness, and Mr. Andrew Alvarado will handle this portion of the proceeding with this witness.
Okay. Is Mr. Alvarado in the back? There he is. Okay. All right, go ahead, call your witness.
So, good morning, Your Honor. Plaintiff's called Dr. Andrea Holmes, who will offer testimony regarding plaintiff's probable right to relief, the imminent and irreparable harm that will result if the agency's rules are allowed to go into effect, and the court's balancing of the equities.
All right, thank you, Mr. Alvarado. Let's go ahead and call Dr. Holmes. Come on up. You're gonna go around the court reporter. There's a bit of a ramp here. It takes people by surprise sometimes. And when you reach the top here, I'll swear you in. Please raise your right hand. Do you solemnly swear and affirm under penalty of perjury that the testimony that you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated. Microphone is on. There should be fresh water and cups should you need it. You may proceed, Mr. Alvarado.
Thank you, Your Honor. Good morning, Dr. Holmes. Can you please introduce yourself to the court and tell us about your education and your work experience?
Yes, I'm Andrea Holmes. I am currently a tenured professor of chemistry in the state of Nebraska. I have a PhD in synthetic and physical organic chemistry and a postdoctoral fellowship from Columbia University. I have been granted several sabbatical leaves from my university to enter into the cannabis industry, where I gained my experience in cannabis testing as well as cannabis processing and manufacturing.
And do you have any experience in the scientific testing of hemp plants?
I do. During my first sabbatical leave from the university, I actually worked for a cannabis testing lab in Denver, Colorado. And then when I came back from my sabbatical leave to the university, I built the very first ISO-certified cannabis testing lab in the state of Nebraska at my university.
And can you explain what an ISO-certified lab is?
The ISO certification that we had is a 17025 certification, and it's an international standard for compliance, for reliability, that basically indicates the quality of the testing, the reproducibility, the non-biased testing, that standard operating procedures are in place, and that there's a quality management system in place.
And what types of tests did your ISO-certified lab perform?
We tested hemp plants.
And how much experience do you have in the hemp industry specifically?
I entered into the hemp industry in 2018, where in Denver, Colorado, I built a hemp extraction and processing facility. And when I came back to Nebraska, I actually also co-own a dispensary, and I work as the chief scientific officer at Katie Pharma. And with regards to the hemp side, I was the global head of the pharmaceutical branch of the cannabinoids in Germany.
And have you published any materials regarding hemp?
I have. I'm the main author of 2 cannabis textbooks, because I implemented a cannabis studies program at my university, and I also have over 40 peer-reviewed published articles, and specifically with regards to the pharmacology of non-psychoactive cannabinoids, I have 2 publications.
And have you ever testified in front of lawmakers about hemp or hemp products?
I have. I live in the state of Nebraska, and I have testified in front of legislation regarding hemp and hemp testing and synthetic versus semi-synthetic versus natural cannabinoids.
And do you have experience on how hemp products are manufactured?
Yes,
And can you explain what that experience is?
certainly. I built a company in Denver, Colorado called Precision Plant Molecules, and there we sourced hemp biomass and extracted it, and then further processed it, isolated it, and purified it for B2B sales.
And
Sorry, for what?
Business to business, B2B.
And what was your involvement in sourcing hemp plant material that would then be processed?
My involvement was the oversight of the sourcing. I didn't do the sourcing myself. We had a supply chain director. My involvement there was that I made sure that the biomass that came in was of high quality, that it met testing requirements that we had in place, such as the evaluation of the certificates of analyses.
And so we'll talk through these in more detail, but just in general, are you familiar with the Texas statutes governing the hemp industry?
Yes, I reviewed them.
And are you familiar with the agency's rules that will regulate the Texas hemp industry if they're allowed to go into effect?
Yes, I have reviewed those as well.
Great, and we'll talk about the statutes and the new rules, but first, let's talk about the underlying chemistry. The rules address Delta-9 THC and THCA. Can you explain to the court what THCA and Delta-9 THC are?
Yes. THCA is a cannabinoid that can be found in the plant cannabis, and it is a molecule that is containing a chemical group referred to as the acidic group, which makes this an acid cannabinoid. And THC itself doesn't have that acidic group on the molecule.
And can you explain what practical effect that difference has between THCA and Delta-9 THC?
THCA and Delta-9 THC are completely different molecules. They have different molecular weights. They have different three-dimensional chemical structures. They have different physical properties, different chemical properties. They also have different pharmacology properties in the human body. So they're completely different molecules. THCA is a non-psychoactive cannabinoid, whereas Delta-9 THC is a psychoactive cannabinoid.
And what is THCA used for?
THCA is used for a lot of different applications. The science that I have studied shows that THCA can be used for the reduction of pain. It can be used for topical applications to reduce inflammation. It is a molecule that has been studied for anti-nausea and anti-vomiting. So the science demonstrates that THCA has a lot of potential in health and wellness and medical applications.
And is THCA used in non-smokable products?
It is, yes.
And what type of products?
THCA is used in topical products, in such as lotions, balms, transdermal patches, bath bombs, sublingual tinctures, and functional foods and beverages.
Now, is it possible for THCA to convert to Delta-9 THC?
Yes.
And how can that happen?
THCA can convert into Delta-9 THC by a process that's referred to as decarboxylation. And this chemical process requires heat, elevated heat, temperature, for the acidic group to dislodge from the molecule as carbon dioxide.
Now, at what temperature does that decarboxylation occur?
Decarboxylation can occur at a very, very low rate at room temperature, but that takes a very long time for decarboxylation to occur at room temperature. But if you heat up the substance at greater than 100 degrees at a longer time, then the THCA can decarboxylate into Delta-9 THC.
So is it accurate to say that if THCA is heated up, it can convert to Delta-9?
Yes.
And you raise an interesting point that THCA could potentially convert to Delta-9 at room temperature. How long would that take?
THCA is a pretty stable compound at room temperature. However, if the THCA is stored for a long, long time, there could be a small percentage that does convert into Delta-9 THC. But it could take like, the rate of conversion is slow, months, maybe even years.
Now, let's go ahead and talk about the Texas statutes first. So under the statute, what is the standard for determining if a plant or hemp product is compliant hemp or non-compliant marijuana?
Your Honor, I'm going to object, one, that this is not a legal expert, and two, the court determines the law and how it applies, and legal testimony is inappropriate.
Response.
Your Honor, I'm having our expert walk through the effect of these rules on the industry and how they are applied in the industry from a scientific level.
The objection's overruled.
So, Dr. Holmes, under the Texas statute, what is the standard for determining if a hemp plant or a hemp product is compliant hemp versus non-compliant marijuana?
The agricultural code clearly defines that hemp is defined as a Delta-9 tetrahydrocannabinol concentration of less than 0.3% on a dry weight basis.
And is that standard the same in the health and safety code as well?
Yes.
Is this presentation on box?
Yes, Your Honor. This is one of our demonstrative exhibits.
Got it. Thank you.
So what is the key metric for compliance under the Texas statute?
The concentration of the Delta-9 THC.
Now, are you familiar with the testing that's required under the Texas statutes?
Yes.
Let's talk about the test required at the agricultural stage first. Can you explain what test is required at the farm level under the agricultural code?
At the farm level, cultivators or farmers have to use what's called the post-decarboxylation test, and this can be done by high-performance liquid chromatography or other reliable methods.
And does that type of testing account for the potential that THCA could convert to Delta-9?
Yes.
And how does it do that?
It's defined as what's called the post-decarboxylation test, and that includes both THCA as well as Delta-9 THC.
Now, under the statute, what happens after that pre-harvest test is conducted?
The farmer has time then to harvest the material. If the test comes back compliant, then the farmer has the permission to hand off the material to the next supply chain partner.
And under the statute, how long does the farmer have to harvest the material after that pre-harvest test is conducted?
Not later than 30 days after the date of the pre-harvest sample is collected.
And is that Texas statute consistent with the 2018 Federal Farm Bill?
Yes.
And is that consistent with the USDA regulations as well?
Yes.
Now, is there a potential that the amount of THCA could change from the date of the pre-harvest test to when the final plant is harvested?
Yes, there's a good chance that changes.
And how is that accounted for in the statute?
So in the statute, it's asking for the total THCA in the pre-harvest testing. And after the sample is collected, the plant will still continue to produce cannabinoids, including THCA. And even after the harvest, once the plant is dried and cured, the cannabinoid levels can still alter. And then once the product has been processed and actually ends up on the retail shelf, the final product also gets tested for compliance of Delta-9 THC.
And so again, under the Texas statute and the federal statutes, farmers have a 30-day window to harvest after the test is conducted?
Yes.
And in your opinion, is that 30-day window important?
The legislation has decided that window is important. My personal opinion is, yes, the farmer needs some time to harvest the material, depending on how much acreage they have. So I think it's an appropriate time window.
Now, let's talk about the manufacturing stage. What tests are required at the manufacturing stage under the Health and Safety Code?
If a manufacturer has access to the pre-harvest test and the pre-harvest test was compliant, then there is no additional testing requirement on the manufacturing side.
Now, Section 151 references various cannabinoids, but what cannabinoids are relevant for compliance purposes?
Delta-9 THC, and on the pre-harvest side, it's Delta-9 THC as well as THCA.
And again, under the statute, would the manufacturer need to retest the hemp plant material for Delta-9 THC before manufacturing it?
If the manufacturer has access to the pre-harvest test, no.
Now let's talk about the testing required at the retail stage of hemp products. Can you tell the court what testing is required for consumable hemp products?
Yes. The testing that's required is that a lab that is ISO certified 17025 determines the concentrations of Delta-9 tetrahydrocannabinol.
And what does that testing of hemp products accomplish?
It accomplishes the determination whether a product is either below or above the 0.3% Delta-9 THC level.
And is it accurate to summarize that at the agricultural stage, they test for potential Delta-9, and on the final products, they test for actual Delta-9?
Yes, they test for actual Delta. Yeah, yes.
Now, does the Health and Safety Code require a total THC test for final products?
No.
Does the statute require testing for THCA at all in final products?
No.
Now, to summarize, can you explain how the testing required under the statutes impacts the Texas hemp market from the farm to manufacturing to the final product?
Sure. So by the statute right now, it's required to do a pre-harvest test on the cultivation side, which is a post-decarboxylation test that includes both THCA as well as Delta-9 THC.
Excuse me, Your Honor, I don't mind demonstrative exhibits, but I would kind of like to know what's being put up and if it's not, what it is.
Yes.
Before-
This one, we've seen this same graphic before, but I think what you're asking is you want counsel to say, Judge, I'm going to be publishing.
A demonstrative so that we're aware of what's going on. Yes,
I agree with you. Please do that going forward.
I understood, Your Honor. And what I'll say is that the next slides include excerpts of the agency's rules. And then there are additional demonstratives that were taken from the opening statement.
And here's my other question. These presentations are supposed to be on box, and they're supposed to be in a specially labeled folder called Other Materials by Judge Request. So this is where demonstratives and presentations go, which means that once you put it in there, all of the counsel for the state can also access the same materials. So I'm going to ask you again, did you put it in the folder under Other Materials?
It is my understanding that it was uploaded to Box this morning, and I believe it should be under the other materials.
Okay. That means, counsel, that you do have access to it, but in addition to that, the court will remind Mr. Alvarado to sort of quickly preview what it is he's publishing. But it should be up there for you to see.
Thank you, Your Honor. No, like I say, we weren't objecting. I would just like to be able to keep track of what's going on.
Okay. But right now, he's going through the presentation that's currently in box, but you will sort of quickly preview what you're publishing before asking questions and moving to the next slide, please, Mr.
Yes, Your
Alvarado.
So Dr. Holmes, can you finish explaining how the testing required under the statutes works in the Texas hemp market?
Sure. So currently under the statute, the testing for plants and products is as follows. There's a pre-harvest test that is a post-decarboxylation test that includes both THCA and Delta-9. And then at the intermediate stage on the manufacturing or processing level, if the manufacturer has access to that pre-harvest test and it was deemed to be compliant as hemp, then that processor can use that material and process it without further testing. And then the final end product that ends up on the retail shelf for the consumer to consume, that is again tested, and this time that testing is the actual THC, not the total decarboxylation, post-decarboxylation THC. It's only Delta-9 THC testing at this time.
Thank you, Dr. Holmes. So next, are you familiar with the agency's new rules?
Yes, I have reviewed them.
Okay, and I would like to pull up a few slides with excerpts of the agency's rules.
All right, you may.
Now, Dr. Holmes, are there any differences between the statute and the agency's rules?
Yes.
Now, I want to talk about the standard for compliance first. What would be the standard for determining if hemp or hemp products can be manufactured and sold in Texas if the agency's rules go into effect?
The agency's rule standard of compliance is now referring to what's called the total Delta-9 THC. And the total Delta-9 THC, which again includes both the THCA as well as Delta-9, is supposed to be less than 0.3% per dry weight.
And how is total Delta-9 defined?
Total Delta-9 is defined as THCA times a factor 0.877 that accounts for the loss of molecular weight, and because the THCA loses carbon dioxide, plus the concentration of Delta-9 THC.
And do you agree with the agency using the term potential total Delta-9?
I would not agree with that potential Delta-9 because the potential Delta-9 THC only refers to if complete decarboxylation occurs from THCA to Delta-9 THC.
Now, what is the effect of that definition?
The effect of the definition of total Delta-9 THC means that all of the products on the manufacturing as well as on the consumer-facing side would now have to undergo a different testing methodology to account for THCA times 0.877 plus Delta-9 THC.
And what effect would that definition have on the ability to sell consumable hemp products in Texas?
The consequences would be that the products that would be currently deemed as compliant under the current statute would then become non-compliant under the new agency rules.
Now, next, I want to talk about the testing that would be required if the agency's rules are allowed to go into effect. And I would like to show you, again, some excerpts of those rules, if that's okay, Your Honor.
You may.
What type of testing would be required at the manufacturing stage if the agency's rules are allowed to go into effect?
On the manufacturing stage, a total THC concentration will have to be tested.
And what effect does that testing have?
It would be a new rule where both THCA and Delta-9 are being taken into account. And so if a product is arriving at the processor that has greater than 0.3% total THC, then that product would be not compliant and could not be further processed.
Now, next, I want to talk about the tests required for hemp products and to show you some excerpts of those rules as well. What testing would be required for hemp products if the agency's rules are allowed to go into effect?
For a hemp product that's consumable, a total THC concentration has to be less than 0.3% or less under the new agency rules.
And so that test would determine the actual amount of Delta-9? Or would it also include the potential for Delta-9 as well?
The total THC accounts for both the THCA as well as the Delta-9 THC.
Now, next I want to talk about the standard for transporting hemp products under the rules and show you an excerpt of that rule as well. Now, would the agency's new compliance standard impact transporting hemp into Texas?
Yes.
And how?
Any kind of raw materials that are being imported into the state of Texas now also have to, under the proposed agency rules, have a total THC test that shows that it's less than 0.3%.
Now, you've walked us through how the new total Delta-9 THC standard is incorporated into different parts of the rules. Is that standard different than the standard set forth in the Texas statute?
Yes.
And how is it different?
It's different on the manufacturing/processing side, where the intermediary processor now has to test the material that comes from the farm for total THC, and it has to also be tested for total THC once the final product, the retail product, is sold on the retail level, and import of material that comes from out of state. All of those are now different than what was under the statute.
Now, next, I would like to walk you through a summary slide that was included in our opening statement presentation that has a summary of the agency's rules and the effect that they have.
All right, you may publish.
So can you kind of walk us through a summary, the changes to the standard for compliance at the agricultural stage and at each other stage of the supply chain?
Yes. So the stages of supply chain on the agricultural level, manufacturing stage, retail stage, and transportation stage, there's the statutes under the agricultural stage that talks about the pre-harvest test, total THC, that includes THCA as well as Delta-9, and that agency rule also has that same regulation. On the manufacturing, none of the Delta-9 THC has to be tested, whereas now under the agency rules, the total Delta-9 has to be accounted for. And on the retail stage, under the statute, it was only Delta-9 THC, whereas now under the proposed agency rules, it would be, again, the total THC, and the same applies for import into the state.
And to summarize, are the agency's new rules consistent with the current Texas statutes?
Your Honor, that is pure legal opinion. It has nothing to do with the industry, and we've been doing it all afternoon.
Well, on that question, sustained.
Okay, I'll move on, Your Honor.
Move on.
So next, I'd like to walk you through a couple of different scenarios. And I have a couple of slides showing how the practical effect of these rules would impact hemp plants and material.
All right, you may publish.
Now, first I want to talk about, can you explain to the court how the change to the compliance standard would impact transporting hemp material?
Yes, sure. So the compliance standard in the pre-harvest, if the pre-harvest is less than 0.3%, then the material can be imported into the state. But if now post-harvest at the processing side or post-harvest, the total THC content goes above that 0.3, such as in this example, 0.375, then under the proposed new rule, that material cannot be brought into the state.
Now, next, I want to walk through a scenario showing how the change impacts consumable hemp products, Your Honor, and I have a similar graphic.
You may proceed and publish.
Now, I want to talk through a scenario about a topical hemp ointment. Have you seen topical products that have both Delta-9 THC and THCA?
I have.
Okay, now, if there was a topical product that had 0.2% Delta-9 THC and 0.2% THCA, how would that product be treated under the statute versus the new rules?
So under the statute, that product would only test for Delta-9 THC, which would in this case be 0.2%, and it would deem that product legal and can be sold to consumers, whereas as under the new agency rules, that now takes into account THCA as well, and if you apply the total THC calculation, then that would be above the 0.3%. In this case, this hypothetical example would lead to a non-compliant product at 0.375.
Now, should we be concerned that people could smoke topical ointments to convert the THCA to Delta-9 THC?
I personally don't think that we should be concerned about people smoking topicals.
Now, Your Honor, the next couple of slides are again a summary of the changes in the agency's rules, and then a graphic that was presented in the opening about how they impact the industry.
All right, you may publish.
So again, if you could just briefly touch on how, if you believe these agencies' rules change the standard for compliance and what impact that would have on the market.
Changing these rules will have an impact on various aspects of the supply chain in the Texas hemp market. So under the current statute, the pre-harvest test to the shelf test would basically allow all of the products to be available to the adult users. Whereas under the new proposed rules, that would change the compliance of the product if you take THCA into consideration. And then there could be a stop in the supply chain at each step of the way, whether that's at the manufacturing stage, distribution stage, or the retail stage.
Thank you very much, Dr. Holmes.
We have a little bit of more time before the lunch break, so let's go ahead and use all of our minutes and get started. You may approach the podium, counsel. And just for the record to be clear, go ahead and say your name before you start. There's a lot of you, and we want to keep all of that straight.
Stephen Loomis with the AG's Office for Defense.
All right, go ahead. You may proceed, counsel.
May it please the court. Dr. Holmes, you talked earlier about being involved with hemp plants. We are still talking about cannabis plants, correct?
Yes.
It's fair to say that all hemp plants are cannabis, but not all cannabis plants are hemp.
That's good, yeah.
Okay. And you talked about Delta-9. Now, Delta-9 THC is a psychotropic agent?
I would call it psychoactive.
Okay. As a psychoactive ingredient, then, it's capable of penetrating the blood-brain barrier and can affect people's judgment, thought process, how they act.
Yes.
And that's one reason health and safety is concerned with that, correct?
I wouldn't know exactly why you're concerned about what exactly. I mean,
well, as an expert here testifying about this, do you understand that people have concerns about high amounts of Delta-9 THC being given to the public?
yeah, I can sympathize with that, yes.
Okay. Now, you've talked about THCA being a completely different molecule, but as you testified to a little earlier, when heat is applied, it does convert to Delta-9 THC, right?
That's correct.
And if the temperature is over 100 degrees, it can convert very rapidly to Delta-9 THC.
If it's over 100 degrees Celsius.
Mm-hmm. And certainly, while we've talked about bath bombs several times today, there are products being offered by some of the plaintiffs in this case, such as vapes, pre-rolled cigarettes, things like that, that are certainly expected to have heat applied to them, correct?
I would think so, yes.
Even tea or coffee might get hot enough to actually start releasing THCA.
Partial decarboxylation can occur with heated temperatures, yes.
Now, if it reaches somewhere around the boiling point of water, the THCA will convert to Delta-9 THC at an 87.7% level, correct?
Yes.
That's the number accepted by all the certified labs, right?
Yes.
That's the number used by the USDA in their
Yes.
regulations, correct?
Yeah. Mhm.
Are you familiar with their regulations as well as the Texas ones?
Which ones? The Texas?
The USDA
statute?
regulations regarding
Yes.
testing, the ones that require THCA to be included in their definition of total THC.
Yes.
And you're aware that the USDA states within that regulation that they are not changing the agricultural definition, but they are using this test in trying to determine how much Delta-9 THC may be in any product.
The USDA is really talking about the cultivation side and the farming side of testing.
True, but they use this 87.7% conversion rate in their tests.
Yes, it is used in all post-decarboxylation calculations.
And even though the federal rules regarding hemp don't mention this test, the USDA specifically says they're using this test and it doesn't change the definition of hemp, correct?
The USDA uses the total THC definition for pre-harvest testing, and it is defined as hemp as long as that is less than 0.3%.
You're also aware that some of the plaintiffs in this case can sell extracts from cannabis plants, correct?
Yes.
And those are condensed forms where they take the THCA, and those powders or crystals can sometimes reach over 90% THCA.
That's very high in potency. I have not seen, well, actually, I have seen THCA crystals at greater than 90% potency. Yes, that's.
Certainly, it's common to have them more than 60%.
If you use a THCA, what's called an isolated molecule, yes.
And that's a lot higher than the 0.2% THCA you use in your hypothetical.
0.3.
You had
You
0.2
said-
Delta-9
Oh,
and
wait, like, one at a time, please.
I beg your pardon.
I think we're talking about 0.3, right, not 0.2.
Your
I see.
hypothetical had 0.2
Oh, this one,
Delta-9 THC.
Oh, yeah, okay.
Oh,
and,
wait, one at a time. I can't take two people down, so please, wait and speak one at a time.
and 0.2 THCA. You remember that?
Yes.
None of the products, well, that was a hypothetical. Did you have a practical example using that number?
Well, that number was a hypothetical example.
Right, because I'm saying I've looked through the web pages of the plaintiffs in this case, and I don't see THCA numbers of 0.2 listed anywhere. I see 30%, 60%. You're not aware of a single item that might have 0.2 plus 0.2 and then meet this hypothetical?
This example that was presented here was a hypothetical example.
You do realize that people are creating cannabis strains and breeding them in order to increase their THCA levels, correct?
Yes.
And that currently they've got some plants that have over 30% just by themselves without any extraction. Yes?
I've seen examples like that, yes.
As an expert in this field, why are the growers trying to get higher levels of THCA into their plants?
Objection, speculation, Your Honor.
He's offering an opinion on everything else related to the industry.
Overruled. You
It's
can
pretty-
ask that question.
It's pretty clear why people are breeding plants with higher levels of THCA, isn't it?
THCA is a cannabinoid that's very popular for adults to consume.
No further questions, Your Honor.
Okay. Anything else for this witness, or it would have to wait after lunch, but I just want to know if she's going to be required to come after lunch.
I just have a few minutes worth of redirect, Your Honor.
If you do, go ahead and come up and
Okay.
let's do that so we can wrap up the witness.
Now, Dr. Holmes, just to clear up a few things. You said that THCA can convert to Delta-9 at 100 degrees Celsius. What is that in Fahrenheit for us Americans?
Over 200 degrees.
Now, the AG's office made a good point, and they are correct that the agency's rules did not change the definition of hemp. But you saw that the agency did add a new definition of total Delta-9 THC, correct?
Yes.
Okay, and what is the practical effect of adding that additional definition?
The practical effect of adding that additional definition is that the industry would not be able to sell or process material that has greater than total THC of 0.3%.
And while the definition of hemp is the same, is the standard for whether a product is compliant and can be sold different or the same?
It's under the new proposed rule would be different.
Now, we talked about a hypothetical topical product with 0.2% THCA. And you haven't seen yourself a product with that specific amount of THCA in it?
I don't specifically recall a product like that.
But have you seen topical products that contain THCA in them?
Yes.
Okay, and if the agency's new rules were to go into effect, what would happen to those topical products that have THCA in them?
If the THCA concentrations were above a certain level so that the total potential THC after decarboxylation would measure greater than 0.3%, then those topicals could not be available for the consumer anymore.
Okay. Thank you, Dr. Holmes.
Mr. Loomis, any?
Very brief, Your Honor.
All right.
In a product being offered by any of the plaintiffs, such as pre-rolled cigarettes or vapes, the THCA would be converted into Delta-9 THC immediately, wouldn't it?
If it's heated up, yes.
At a rate of 87.7%.
Yes.
No further questions.
Nothing further, Your Honor.
All right, thank you. Okay, you may step down, Doctor. All right, so as indicated before, we will be taking a lunch break. I will come back right at 1:30 instead of 2, and we'll just keep going. So 1:30, go ahead and make your way back at around 1:20 so that you're set up and ready. I'll come out at 1:30, we'll keep going. I understand I'm losing Mr. Berg, Mr. Dustin, and Mr. Loomis, and that I will see you all tomorrow morning. But then the rest will be reshifted, and I think I've memorized the faces, so I'll be able to move you in my seating chart. Have a good lunch. See you after lunch. All right. I did want to ask counsel to approach the bench. Just give me a second, Mr. Shu, off the record. If you can approach. And the rest of you are excused. Thank you. With regards to the I took your word for it.
Yes, yeah, we'll.
It was probably the exhibits folder, but we don't know which numbers.
Damn the torpedoes. Forget the comments.
Forget all the economic analysis.
Yeah.
The fact that they didn't republish.
Facts are purpose. We're gonna do what we want to do.
Yeah, and there's been a lot of sensation.
Good to see you, brother.
Sweet eggs about the cost of it.
I'm serious. Take no chair.
Yep.
I'm seriously wondering how many more witnesses how many more witnesses we're going to need after today.
Probably not very many. Yeah, I think that's. Yeah.
No, I'm bringing it up.
Yeah.
Thanks.
Yeah.
Would you look and make sure this is all the
Now, is that need to be? Is that your lobby firm's office space, or is that?
No,
Yes,
we're all-
yep, demonstrative 5, great.
Okay, good.
Probably get them an
I
extra
mean,
office.
we've got Scott Stevens who looks like
Yeah.
and he is now. Maybe the two knowledgeable.
David, did you want to talk to David?
Yeah. Trying to figure out how many people we really need out of my group.
I agree.
What?
I said I agree.
Yeah. We good to go on your computer?
Yeah, I'm just making sure it actually connects again. And for exhibit 27,
Give you
that
that.
and so I'm gonna hand it to her first before I have you pull it up.
And all the tabs are going.
Yeah.
What are you gonna start with?
I'm actually gonna start with showing him exhibit 27. I'm trying to get that video. Okay.
I get it.
No. And then you'll
Okay,
say,
so I was told
you'll say
you're
one.
gonna sit in different
Yeah.
places, so
Yep.
we have
Exactly.
Rick,
Demonstrative.
Thornburg, and Mr. Ingram. Okay.
I shouldn't have. You're thinking exactly.
Yeah. Oh, and actually, I'm gonna delete
Know
that.
that, right? I just want you to
Yeah.
know you know you're killing
Thank
me.
you.
Record show, we're not moving.
I'm glad I decided to give you, to use your names. Just quick, for reporting, I have to, you each have your own designation. And when there's multiple attorneys, I have to decide what that designation is gonna be. And, a lot of times for just ease, I do numbers. So like 1, 1, 2, 2, 3, 3. And I'm glad I didn't do that this time. I used your name, your last name. So the switch is that bad in my mind, but.
Well, we appreciate it.
Yeah, sorry, I'm whining.
Did you get my email with the
We can make it fine.
terms and spellings? I hope I got the right email.
Was that there?
Yes, it is.
Yes, I did, thank you so much.
Are they gonna put them on there? How do you adopt?
I know, it's hilarious.
Let's see if I've got your. My computer is in settings, or is it displaying it there? Do we have to wait?
Okay.
Yeah, I think she has to do
Okay.
something
Okay,
up there.
and then I can hit the button over. Okay, I just
Yeah,
want to make
did
sure.
you try hitting the button just in case?
I tried this now and it's not going up there?
Yeah,
It
so
did-
I think that
okay.
on her end.
And it worked
yes,
early this morning, so it should be fine.
It
Okay.
should be fine, yeah, I don't think there's an issue.
Your thinking
Yeah.
is exactly like my thinking. Cool.
Oh my gosh, my heels. I'm still in my walking shoe.
Damn your chair. I don't think anybody noticed. All right. When I was starting my career at Michael Smith, it was Pete. Pete was our graphics guy. So
Yeah.
I get to be Pete.
And I think she's saying once the judge gets in, she'll do something, and then you can hit that button, and that'll display.
You say that the button's working now.
It's not now, but I think when the judge gets up there, she'll do something that'll allow us to display it.
Okay.
Other than that, just unplugging this and
Other than that, yeah.
and it worked this morning, so and my computer's recognizing it as a display.
Okay. All right.
Yeah, so I think it's just a matter
Hopefully I
of
don't fuck it up.
button pushing.
Can I see it real quick?
Yeah.
I am.
Preamble, right?
These are the final. The proposed rules is 16.
Final.
And I'm not expecting to use the final rules much.
Okay, I need to get used to that. Your scroll is reversed from mine.
Okay.
And then that's good.
Good practicing. And then proposed rules is where we'll go through in the different sections.
Yep.
And the zoom is moved all the way over here.
Got it. All right. Easy. do you have any mints?
I do.
Take one of those. Always depend on. Thank you so much. Andrea,
She may have some better ones.
This is why it's good to
I
have
have the
women on
swag
this.
ones. Those are quality lifesavers.
y'all have purses and mints and all sorts of things.
I'm done. Yeah, my first trial ever, my paralegal was like the mama bear. And she brought snacks, she brought candies, all the things we needed. It's like,
Could be better down the line. It could be.
Do Bo and then Lauren.
yeah. Bo, Lauren, and then Ryan from Haifa.
Right. Okay.
And then
And what about Mark? Not today.
Mark. Yeah.
That'll work.
Yeah. And you'll go around and up the ramp.
Thanks for wasting your time and ours.
You look like you have great knowledge. Use of the English language.
You know what, one of my favorite things to like pitch in response to a reading mail. Thank you for your, give it the attention it deserves.
That's basically what I got.
That's what you.
That's basically what I got.
All rise, the 161st back in session. Right, you may be seated. Good afternoon. I hope everybody had a good lunch break. We're gonna go ahead and get started. Ms. Pallas, let me know when you're ready.
I'm ready, Judge.
Okay, we're gonna go back on the record on D1GN 26-002511. Please call your next witness.
Good afternoon, Your Honor. Plaintiff's call, Bo Whitney.
All right, come on up. Oh, microphone is. Please raise your right hand, sir. Do you solemnly swear and affirm under penalty of perjury that the testimony that you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
You may be seated. There's water for you if you need it, and look up at counsel when you're ready.
Good afternoon, Mr. Whitney. Can you please tell the court about your experience and your background in economics?
Well, I have a
I'm sorry, could you please state and spell your name for the record?
Oh, sure. My name is Beau Whitney, Beauwhitney.
Thank you, sir.
And I'm the chief economist at Whitney Economics. So I have a bachelor's degree in math and philosophy, and then a master's degree in business from Thunderbird.
And how long have you worked in the economic industry?
Well, I did applied economics for Intel Corporation and Triquint Semiconductor, running their supply chains, their global supply chains. And then I transferred that over, teaching economics at a university level. And then I've been full-time in the cannabis space, including hemp, for 12 years now.
And can you tell us about your economic work in the hemp industry specifically?
Yeah, I've produced a lot of reports on the hemp industry, ranging from the total addressable market to employment, the amount of taxes. I've reviewed policy. So I've published an extensive group of reports, particularly since the signing of the 2018 Farm Bill.
And what was the purpose of those economic reports?
Well, there's not a whole lot of data out there in the available, and so I was just there to help educate people on the numbers, and to serve as a resource for operators and investors and policymakers to make informed decisions.
And who did you provide your economic analysis reports to?
A lot of my reports are published for the public consumption. Most of them are distributed for free on my website. And so once again, it's for operators and policymakers, regulators, legislators, and I even provide inputs into other governments.
And can you tell us about your experience providing your economic analysis to legislatures?
Yeah, once again, they're looking for decisions. I found that data takes the emotions out of issues. And so I provide data on the impacts of their policies. We don't take a position on the legalization or on particular issues, but we definitely provide the data for the legislators to use while they're making and developing their policies.
And have you done any economic analysis about Texas specifically?
Yes, I've done a series of reports. It started really in 2023. I did a national report called the U.S. National Cannabinoid Report. And it was a survey that went out to 40,000 businesses, got responses from 45 states, and then it broke out the employment and taxes and the total addressable markets by state. And then with respect to Texas, there were people that were saying, well, can you give us a similar report but specific to Texas? And so I published two reports, one in 2023 and then a refresh in 2025 specifically on the Texas market.
And you prepared that 2025 economic impact report that was included as part of Plaintiff's petition, right?
Yes, that's correct.
Have you had an opportunity to prepare an updated version of that report?
Yes, I leveraged the results from the surveys in 2025 and simply changed the number of businesses that had licenses in the state of Texas, and then based my projections off of just the refreshed number of businesses that are currently operating in the state.
Now, were there any changes from your 2025 economic report to the new report you created in 2026?
Yeah, one thing I noticed is that the number of retailers declined. And as a result, because there's so much sales on the retail side, the total addressable market and the actual sales throughout the supply chain declined since that 2025 report.
May I approach the witness, Your Honor?
You may.
I'm going to show you what's been marked as Exhibit P27. Would you like a copy, Your Honor?
Yes, actually, I can access it on box. That's my preferred. Was this the previously admitted exhibit?
This one has not been admitted.
Okay, I'll get there. Okay.
Now, Mr. Whitney, can you explain what the document in front of you is?
Yeah, this is a document that I produced just recently with the intention of assessing the Texas market, looking at the impact of some of the rules, and looking at some of the claims that were made in the proposed rules. Yeah.
Now, are there industry standard methodologies or best practices for preparing economic impact reports like this?
Yeah, of course there are. And a lot of times to get good granular data, economists utilize surveys. And so they go directly out to the people actually doing the work and ask them what their thoughts are. So part of this is a summary on the quantitative side, and part of it is also on the qualitative side.
And how did you prepare this updated report?
On this updated report, I just simply leveraged the average revenues from the 2025 report and then adjusted it for the number of operating businesses or licensed businesses. I did the same thing for the jobs and wages and taxes.
And did you have a statistically viable sample of data for this report?
Yes, I did. In the 2025 report, we had a 95% confidence level with a plus or minus margin of error of 5%. So that's a pretty high standard.
And the economic information in this report, is that the type of information that you've presented to legislatures before?
Yes, it's very similar. It's a lot of times legislators and regulators want to understand jobs and taxes in particular, what the economic impacts of these policies are. So yeah, it's very similar.
And do you know if any particular legislature has actually relied on your economic analysis in these reports?
Yeah, I don't know all of them, but I do know that there have been instances where, say, I flew into Florida during a legislative session and discussed some of my findings with the Florida legislators. And that was during a period where they were trying to make policy decisions. So yeah, they use my data in that. And then I believe that Governor Abbott reviewed or had access to my 2025 report on the Texas market.
Your Honor, at this point, plaintiffs move to admit Exhibit P27 into the record.
No objection. P27 is admitted.
Thank you, Your Honor. And if you could give access for us to share our screen.
Attorney 1, correct? Yeah. So did you push the button? You're attorney 3. Okay, sorry, I looked at the wrong. Go ahead and push the button. There it is.
Thank you, Your Honor, and thank you, JR. So, JR, if you could please go down to page 4. And if you could zoom in on the table at the bottom. So, Mr. Whitney, we're going to talk through each of these numbers specifically and how you determine these figures. Now, the first figure I see on the table is total economic impact of a little over $9.8 billion. And you have a note that it was driven by a 2.4x multiplier. Can you explain to the court what that means and why you included that multiplier?
Yeah, the concept of a multiplier effect in economics is pretty basic. It's for every dollar that is spent in an economy, there's this ripple effect. And so more economic activity is derived beyond that $1. And so the 2x multiplier says that for every dollar that's spent at the retail level for hemp in Texas, in this case, there's a $2.4 impact to the economy.
And is it appropriate to use that 2.4 times multiplier for the hemp industry?
Yeah, in fact, it's conservative, in my opinion. There's been some analysis done that puts a hemp multiplier at between 7 times and 12 times. And for comparison, the construction industry has a 6.1x multiplier, and the National Park System has a 10x multiplier, just to provide some context. And so a 2.4x multiplier is pretty conservative, but that's kind of how we roll at Whitney Economics.
So can you explain to the court what a $9.8 billion total economic impact means?
Yeah, basically this took the $4.1 billion retail revenue and multiplied it by 2.4, and that's where we derive the $9.9 billion of economic impact.
And in practical day-to-day terms, what does that figure represent?
It represents the total amount of influence that hemp has on the Texas economy.
Now, the next number I see is the $5.09 billion for total combined revenue, excluding cultivation. Can you explain what that means?
Yeah, so through the utilization of the surveys, we were able to get average revenues broken down by sector. And so we simply multiplied each sector by its average revenue. And that's where we got the 4.1 and the others. And then when we added it all up between manufacturing, wholesale, and retail, then it totaled $5.1 billion.
Now, you mentioned you got information from surveys. Did you get information from any other source?
Yeah, sure. I like to rely on state regulators for data because that's the data of record. And so in this instance, I utilized the number of licenses based upon the information provided from the state.
And is that 5.09 billion figure accurate in your opinion?
Yeah, I'm very confident in that number.
Now, the next 3 lines are the total revenue for retail, wholesale, and manufacturing. Can you please explain to the court what those mean and how you determine those figures?
Yeah, that's based upon the surveys from 2025. There was an average revenue per retailer, per wholesaler, per manufacturer. And so we were able to take the license numbers. For example, I think there's 7,262 retailers. And so we multiplied that by the average revenue per year. And that's how we got the $4.1 billion. The same concept applies for the wholesale and the manufacturing as well.
And again, where did you get that information from for your analysis?
That was from a combination of the state from a license perspective and then from the surveys that we conducted in 2025.
Now, the next figure is a total sales tax revenue of $257 million. Can you explain to the court what that means and how you calculated that figure?
Yeah, on that, I looked at retail only, that $4.1 billion, and multiplied it by the retail sales tax that's present in Texas at 6.25%. And then that's a pretty simple math equation. I did not include any local or county taxes on top of that. It's strictly the state sales tax.
Great. And the next line is total employment, and there's a number 48,882. What does that mean?
What we did there is we looked at the different sectors and the number of jobs per business within those sectors, and then multiplied that by the number of licenses and then added it all up.
And the last row is total wages of $1.9 billion. How did you determine that figure?
So on that, we looked at the average wage, and this is based upon the surveys. So the average wages that are paid per retailer, per wholesaler, per manufacturer. multiply that by the number of employees at each firm, multiplied by the number of licenses, and that's where we came up with the total wages. We just added it all up.
So to summarize, based on your analysis, what is the total economic impact of the current Texas hemp industry?
That's that $9.9 billion.
Now, JR, if you could scroll down a little bit to the next page and the next table. Now, Mr. Whitney, there's a table here where the top row says negative economic impact potential. Did you determine or what does that mean? What did you determine there?
So within these surveys, we ask not only quantitative questions like the number of employees and the average wage and average revenues and stuff, but we also ask about what they would do under certain policy conditions. In this one, and we've been asking that a very similar question from state to state to state to state. And so we asked if there were policies that ban the sales of hemp, consumable hemp products, then what would you do as a business? And so some businesses, so that's kind of how the basis of this data set.
And looking at the bottom row, how did you determine that the agency's changes would have an estimated negative impact of almost $7.2 billion?
Well, in the responses from the surveys, a lot of the retailers and wholesalers and manufacturers said that they would either go out of business as a result of policy changes or they would move to another state. And so we looked at the revenues that were derived from those companies that would leave or go out of business, and that was the reduced retail and other reduced revenues. And then the rest is just applying the tax rate or the wage rate or what have you. And so by looking at the total impact of the proposed rules, it looked at the reduction in retail revenue at $3 billion and then applied that same multiplier effect, the 2.4, to derive the $7.2 billion in economic impact.
And how did you determine the number of reduction in employees?
That was coming directly from the survey responses themselves. And it's not dissimilar to the results in other states.
Now, next I want to talk to you about the agency's rulemaking process. But first, have you reviewed the proposed rules that were published in December 26th of 2025?
Yes, I have.
And have you reviewed the final adopted rules published on March 20th of 2026?
Yes.
Okay, so first I want to go through the proposed rules. JR, if you could pull up Exhibit P16. Now, Mr. Whitney, do you recognize this document?
Yes, I do.
And do you recognize that this is the proposed rules that were published on December 26th of 2025?
Yes.
Now, these proposed rules contain a section for fiscal note, government growth impact statement, local employment impact, cost to regulated businesses, and public benefits and costs. Did the final adopted rules contain those same sections?
No, they didn't.
Okay. Now, from an economic standpoint, were there any meaningful changes from the proposed rules to the final adopted rules?
Yeah, there was changes made to the amount of fees. For example, the fees in the final adopted rules were lower than what was being proposed in these.
Now, did the agency provide any additional financial analysis in the final adopted rules?
No.
Now, sticking here with Exhibit 16, the proposed rules, do you see the section titled Fiscal Note?
I do.
And who contributed the financial information for this section?
Well, it was noted that Christy Burton, the Chief Financial Officer, provided those estimates.
And what is your understanding of this fiscal note?
My understanding is that that enforcing or administering the rules doesn't have a foreseeable implication related to costs, and then they list some of the revenues that was being estimated to be derived as a result of those new fees.
And do you see the sentence where it says the estimated increase in revenue as a result of enforcing and administering the rules as proposed?
I do.
And what does that mean in lay terms?
Well, they said that there will be a increase in revenue of $202 million per year as a result of this new fee structure.
Now, you understand that that $202 million figure was based off of the original fees that were proposed, but those fees were actually reduced in the final rules, right?
That's correct.
How much revenue would the state generate based on the fees in the final adopted rules?
I think I estimated that at $43 million.
And how did you determine that figure?
I looked at the number of actual licensees and then multiplied that by the fee associated with each license type.
And do you believe that's an accurate way to determine the amount of revenue the state would generate based off the fees in the final adopted rules?
Yeah, certainly.
Now, sticking with that fiscal note, according to the agency, what would be the increased cost to administer and enforce these new rules?
Yeah, the increased cost was $69,315 in fiscal year 2026, and then $5,648 per year through 2030.
Now, the next section is titled Government Growth Impact Statement. Did you have an opportunity to review that as well?
I did.
And JR, if you could go to section 2 on the top right. So, Mr. Whitney, can you read section number 2?
Implementation of the proposed rules will not affect the number of DSHS employee positions.
What does that mean?
It means that there won't be an increase in headcount, in layman's terms.
Now, was there any statement in the proposed rules that because DSHS can only inspect each license once every 6 to 7 years, they need to hire over 20 additional full-time employees?
There was no background on that or many other things.
And again, what did the agency say to the public about the need for more DSHS employees to administer these programs?
It said that they wouldn't need any.
Now, based on the agency's statement that they will not need to hire any new employees, do you believe the estimated increase in cost of $70,000 in the first year and just under $6,000 in the next few years is a reasonable estimate?
Yeah, it seemed pretty reasonable to me.
And why do you think that?
Well, I assumed that there would be some IT-related costs or something of that nature in order to implement this. And then once it was implemented, then it would just be sustaining costs.
Now, looking back at the growth statement, sections 3 and 4 state that the proposed rules require an increased legislative appropriations and increase in fees paid to DSHS. Based on the statements in the proposed rules, how much would the agency need to obtain through either legislative appropriation or through increased fees to administer this program?
Well, it'd be that $69,000, $69,315.
And again, you reviewed the final adopted rules as well, right?
I did.
What analysis did the agency conduct to determine if the fees they were charging corresponded to the actual cost of administering the program in the proposed rules?
What processes? It didn't seem like there was much of a process. They didn't provide the background or the methodology and how they derived those numbers.
Did you see any analysis connecting the amount of the fees to the cost of administering the program in the final adopted rules?
No.
Now, going back to that growth statement, can you read section 8?
Oh, sorry. DSHS has insufficient information to determine the proposed rules' effects on the state's economy.
Now, you just testified about your analysis of the effect of the proposed rules on the economy, correct?
That is correct.
And where did you get the information you used to determine the proposed rules' effect on the state economy?
I got it from surveys and from the state themselves.
Do you agree with the statement that DSHS has insufficient information to determine the proposed rules' effect on the state's economy?
Oh, not at all. In fact, they have more than enough information available to make to develop an understanding of what the impact would be on the state economy.
Now, next, I want to talk through the change in the fees. And JR, if you could pull up demonstrative number 5. Now, Mr. Whitney, are you aware of how much the fees have changed, I guess, from the original fees to the final rules?
Yes, I am.
And how much did the fees increase for each type of fee here?
For manufacturing, it increased from $250 to $10,000 in the final rule, and then from $150 on the retail level to $5,000. But then there was also the change in ownership fee that increased from $250 to $10,000, and then there was the delinquency fees as well.
Now, based on your experience, what purpose will these fees serve?
Well, from my understanding, it was public safety and law enforcement. That's what the fees were stated to be required for.
Now, will the fees generate enough money to cover the cost of administering the program and the new rules?
Yeah, in fact, it's more than enough. Based upon data from the comptroller's office, they had already a surplus of funds to support their program.
So will the state be generating revenue from these fees on top of covering the cost of administering the program?
Yes.
Now, in your opinion, what effect will these increased fees have on businesses in the Texas hemp industry?
It'll have, in my opinion, a rather devastating effect. It will reduce margins. It'll put people out of business, businesses out of business. It'll reduce employment. It will limit the supply to the consumers. So consumer access will be impacted. It'll reduce tax revenues by the state and by the counties and by the local communities. And then it'll also increase expenditures. So the impact there will be that since there's displaced workers now and business failures, then there'll be an increase in unemployment insurance payments. There'll also be an increase in healthcare expenditures because people will no longer have the insurance from their employer, and so they'll have to have that backfilled by the state.
Now, will these increased fees have an impact on Texas farmers in the hemp industry?
Absolutely. What this does is it creates a lot of uncertainty, and farmers don't operate well in uncertainty. And so it'll increase costs. Potentially, they may not have a home for their crop due to the business failures and a reduction of demand. And so this will have an impact on farmers.
Now, going back to Exhibit P16, I want to talk about the next section that was included as part of the rulemaking process in the proposed rules. Do you see the section titled Small Business, Microbusiness, and Rural Community Impact Analysis?
I do.
And do you agree with the agency's CFO that there will be an adverse economic effect on small businesses or microbusinesses or rural communities due to the higher licensing and registration fees and higher costs to comply with the proposed rule updates?
Yeah, I do. I see that.
Now, did the agency analyze or quantify what that adverse economic effect would be?
They have a number there, yes.
Okay. And do you believe that number is accurate?
I do not.
And why not?
It appears as though the $202 million is simply a regurgitation of what the CFO had said in the increase in fees, fee revenue. But there's a lot of different other impacts and costs associated with that that go well beyond that $202 million.
And did you see anywhere in the rulemaking process where the agency considered those other increased costs?
No.
Now, did the agency analyze or quantify the cost burden of the new rules on a per business basis?
No, they didn't.
Did the agency analyze or quantify the proposed rules' effect on margins or the viability of businesses?
No.
Did the agency analyze or quantify the likelihood of business closures or relocation out of state?
No.
Without that analysis, could the agency accurately determine the impact of the new rules on small businesses and rural communities?
Not at all, no.
Now, without analyzing those impacts, can someone meaningfully compare different regulatory approaches and different ways to structure these fees?
No, it's nearly impossible.
Now, you see, the agency did write that alternatives would not be consistent with ensuring the health and safety of minors. Was there any analysis in the rulemaking record to support that conclusion?
Not that I could find, no.
Did you see anything in these proposed rules where the agency considered alternative ways to structure these fees?
No, I did not.
Are there alternate ways to structure these fees?
Oh, yeah, certainly. In order to minimize the impact, there could have been a tiered structure on the fees. For example, if there's small businesses, rural businesses, et cetera, then they could have had a different fee structure for them relative to larger actors in the space. They could have also have talked to the legislature to get increase in funding from the legislature themselves. There's all sorts of different alternatives that don't appear to be considered in this analysis.
So did the agency provide any comparison of the economic impact of those different alternate methods?
No.
Now, I want to talk about the next section next, local employment impact. Do you agree that the agency's new rules will have an impact on local economy?
Yes, I do.
Now, you were in court today, right?
Yes.
And did you hear the AG's office explain that if an agency determines that their rules will have an effect on the local employment, then they shall describe the probable effect that rule will have on each local area for the next 5 years?
Yeah, I heard that.
Did you see anywhere in these proposed rules where they provided that analysis?
No.
How could the agency have analyzed the impact of the new proposed rules on local employment?
Well, they have a list of the licenses by town, by jurisdiction, so they know the number of businesses and business types there. They also have access to the number of employees at those businesses and the taxes that are paid, the revenues, all of that. And so the state has access to that. So that's a pretty easy lift that doesn't require a whole lot of expenditures or anything like that. In addition, since they're the regulators, they can send out a survey and ask the businesses directly what the impact of those proposed policies would be.
Now, would it have been really hard or really expensive to get that data to make this analysis?
No, not at all.
And how do you know that?
Because I've done it myself.
Now, do you agree with the agency that they did not have sufficient data to define the impact of these proposed rules on the local economy?
No, they had more than enough data to define the impacts.
Did the agency provide any analysis of local or even regional economic impact?
No.
did the agency provide an estimate of the effect that these rules would actually have on local employment?
No.
Now, based on your analysis on the statewide level, would the agency's new rules have an impact on local employment?
Yes, they would.
And what would that impact be?
Well, we had reviewed it a little bit earlier. Here, let me refer to it. On statewide employment, there would be a projected decline of employment by over 36,000 workers, and generating earning $1.4 billion in wages.
And how could you or another economist take that statewide information and then apply it to analyze the impact on a local level?
Yeah, I could have done it. I just kind of ran out of time due to the timing of the hearing. But it would be pretty simple. Like I mentioned, the regulators have the location of each license, and as a result, they could do the same type of exercise.
Now, the next section is titled Public Benefit and Costs. Did you have a chance to review this section as well?
Yes.
Now, what costs to the public did the agency consider in this section?
It just seemed, well, they had business costs, but they don't seem to have listed details of the public costs.
Now, the agency did note that one of the public costs would be higher fees, right?
Correct.
And another public cost would be the cost associated with complying with the age verification requirements, right?
That is correct.
Were there any other costs that were analyzed in this section?
No.
Did the agency take into account costs of complying with additional testing requirements?
No, they did not.
Is there any indication the agency considered the economic impact of changing the standard for what constitutes hemp?
No.
Is there any indication the agency considered the public cost of increasing restrictions on transporting hemp in Texas?
No.
In your opinion, what would it cost the public if these new rules are allowed to go into effect?
Well, there's lots of costs associated with this. Like I said, lack of access. There would be potential increases in healthcare expenditures by the individuals. There would be a lot of different costs, and in addition to the displaced workers and all that.
And did the agency consider all of those costs?
No, they only relegated it to those two costs.
So did the agency consider any of those other costs that you just listed out?
No.
What was your impression of the financial analysis the agency conducted in the rulemaking process?
Can you repeat the question?
What was your impression of the financial analysis that the agency conducted during this rulemaking process?
I found it surface level and incomplete, to be quite frank. There was lots of data available to them, and they just didn't leverage it. They had more than enough time to conduct this analysis, and they didn't seem to take the time to do it. So it's really not credible.
And in your opinion, did the agency provide a comprehensive economic analysis during this rulemaking process?
No, they did not.
And in your opinion, what effect did the agency's failure to conduct that comprehensive economic analysis have?
Well, the effect is that when people are making decisions about these policies and providing inputs, they didn't have sufficient data in order to make informed decisions.
And just to wrap this up, what would the economic impact of the agency's proposed rules be on the Texas hemp market?
That's the $7.2 billion of economic impact.
Thank you, Mr. Whitney. I pass the witness.
All right. Thank you, Mr. Alvarado. Counsel, you may come up to the podium. Ms. Thorburn, correct?
Yes, Your Honor, Thorburn. Allie Thorburn for the state defendants.
Thank you. You may proceed.
I'm sorry, did the microphone get shut off?
It's got a light, but I can speak
Okay.
up.
Oh, yes, please.
Okay, I
Thank
will
you.
speak up.
Thank you.
Good afternoon.
Hi.
Thank you for being with us today, and I've just got some questions for you.
Okay.
Okay. You are not a lawyer,
No, I'm not.
so you're not offering any legal opinions today.
No, I'm just here to talk about the economics.
You didn't conduct a new survey specifically for this case, correct?
That's correct.
You used an old survey that you did in 2025,
Correct.
and then you added a little bit of new data to it.
Yes, I added the number of licenses that are currently issued by the state.
And you testified on direct, it's that the number of licenses actually declined since your last survey,
Number of retail licenses, yes.
and that would
I'm
be,
sorry, the number of,
Retail licenses,
thank you.
and that would have been from 2025.
correct.
And that was
Technically,
before.
I guess technically, at the end of December 2024, heading into 2025, so first of 2025, yeah.
And so the number declined before these rules went into effect.
Oh, no, the decline was comparing today's or the licenses as of April 9th to the previous data that I had published, which was basically at the end of 2024, early 2025.
And your report or your summary here doesn't break down which licenses decreased when.
It shows the retail license decline by year, or it shows a comparison of the last 4 years.
It doesn't show how many licenses declined per week.
No, it doesn't.
You discussed on direct a 2.4 multiplier that you used. And you explained it could be higher. You called yours conservative.
I did.
In your summary, you don't explain how you reached that number, though. Correct?
That's correct. It's been viewed as an industry standard.
In the chart on page 4 of your summary, you explained on direct that you used averages to conduct, to reach the numbers of total retail revenue and total wages. Is that correct?
That's correct.
And you understand that averages can be skewed?
Yeah. But I did actually.
I'm sorry, objection, motion to strike after yes.
Just wait for the next question, and then there will be an opportunity by the other attorney to ask you any clarifying questions. So
Okay.
just at
Sorry
this
about
point,
that. Yeah.
it's all
I got
right.
it.
At this point, she's asking the questions, you're answering just her question. Wait for the next one. The attorneys on the plaintiff side will come back and ask you more.
All right, thank you.
On direct, you testified pretty extensively about how you conclude that the state failed to do a credible cost analysis, right?
That's correct.
But you don't know what variables the state considered.
They didn't provide that in their methodology or any of their assumptions.
So that's a yes, you don't know.
I don't know.
You mention in your summary that that it appears the state conducted a static analysis.
Yes.
You don't know that that's true.
It's pretty evident from the numbers that they derived that they took only one variable, meaning the increase in fees, and kept everything else equal. So they did not consider reductions in the number of firms, the reductions in employment and all that. So by keeping everything else equal and only adjusting for one variable, that's the definition of a static model, static scoring.
But you just testified that you don't know the variables that the state used, correct?
Correct.
On page 6 of your summary, it's going to be the first sentence below the chart that says statewide jobs and wages. There, you say, the reaction to policy changes and uncertainty has already impacted the market. Is that correct?
Yes.
You don't provide an analysis in this summary of how you reached that conclusion, correct?
That's correct.
On direct, you spoke about a survey that you did, right?
Yes.
And one of those surveys, you asked some businesses and some consumers questions about what would happen if some laws were passed. Is that correct?
Yes.
Okay. And on page 7 at the top, that's a chart of summarizing that analysis, right?
That is correct.
That's the analysis you used?
Yes.
And that chart says you asked if laws are passed prohibiting sales of CBD or cannabinoid products, what will you do? Correct?
Correct.
CBD is different than THC.
It's one of the compounds present in the hemp plants, yes.
It's a different compound.
It's a different compound.
And it's also a different compound from Delta-9.
Correct.
It's different from THCA.
Yes.
And cannabinoid products, that's a pretty general term, right?
Yes, it is.
It encompasses all sorts of cannabinoid products,
Correct.
not just THCA.
Correct.
The next chart on that page, impact of restrictions or bans, that uses the data from the above chart.
Yes, it looks at how many businesses will either fail or move, what the impact on employment, sales tax, all that.
And that's based on the data from the prior chart that we just discussed.
Correct.
I want to talk about the fiscal note that my friends on the other side and you discussed pretty extensively on direct. You are aware that the fees in the fiscal note were higher than the final fees.
Correct.
And I think you characterize that as a material change.
Yeah, it's significant.
And you don't know what variables the agency considered when they performed their fiscal analysis.
There was no articulation of their methodology or assumptions in there.
So you don't know.
Correct.
And that fiscal note then was based on data that's different from the final proposed rules.
Yes.
And you can't say what analysis they did conduct to reach those numbers.
Right.
And so you can't say what analysis they conducted to reach the final proposed rule numbers, correct?
That's the whole problem with the analysis that they're doing is they don't provide the details, and so it's not just me that's impacted in terms of understanding, but it's also the consumers and regulators and policymakers and business owners.
Objection. Motion to strike, non-responsive.
Ask the question again.
You did not know what variables they used, correct?
Correct.
But are you aware that the dishes is only allowed to hire new full-time employees upon certain conditions?
I'm not familiar with their hiring policies.
Are you aware of the conditions upon the revenue? Are you aware about the legal conditions placed upon the revenue collected by dishes?
From a basic understanding, their revenues must simply cover the costs of regulating the industry.
You're not aware of any additional requirements?
Not offhand.
Is it your contention today that 1.3 million is enough to run this program?
I think I said in my direct statement that it's going to increase slightly due to what the CFO said by 69,315. So there'll be a slight increase, but between that 1.3 and 1.4 is what I would estimate that to be based upon the inputs from the CFO and others.
Your summary doesn't include anything showing you considered a 2-year inspection cycle, correct?
Yeah, I wasn't aware of that, the 2-year inspection cycle. I don't know where that came from.
So you also didn't consider the need to collaborate with DPS?
Once again, I wasn't familiar with that.
The need to collaborate with SOA?
No.
Are you aware that, let me rephrase that, you are aware that the TABC doesn't do the type of tiered pricing you described on direct, correct?
I'm not aware of that.
Let's look at page 7 of your summary. I want to look at the first sentence under impact analysis and expert findings. At the end of the first line, it starts with non. Do you see that the end of the first line has non-dash?
Yeah.
Okay, and that word is non-statutory, correct?
Yeah.
You're not offering a legal conclusion here, though, right?
It's more the impact of the changes of the standards and what that would be.
You're not offering a legal conclusion that these are non-statutory standards.
No.
On direct, you discussed the public cost to these new rules. And one of the things that you said, okay, do you recall discussing public cost?
Yes.
You don't know how much the state spends on inspections, do you?
The state didn't provide a breakdown of those costs.
So you don't know?
No.
You don't know the exact cost of administering the program?
Well, I know what was authorized by the legislature at that $1.3 million, but that's, other than that, no, I don't.
You didn't do an analysis on how many people will be unemployed based on these rules.
No, I did.
You didn't do an analysis based on describing how many people who may lose their jobs will be unemployed for an extended period of time.
No, I just said that there would be workers displaced.
And that was based on the survey you took where you asked a question concerning prohibiting sales of CBD or cannabinoids,
Correct.
not just limiting THCA. Correct.
Is it possible that I can explain that, or should that be on?
So this calls for a yes or no answer. However, the attorneys for the plaintiff will have an opportunity to come back and ask more questions.
Okay, correct.
Unless she asks you for an explanation.
Okay.
So you don't know how many people under your analysis, how long they'll be unemployed for.
Correct, I don't know.
You don't know that they will even need state health services.
It was my opinion that they would, yes.
But you don't know.
No.
I'll pass the witness.
Thank you. You may be seated, counsel. All right, Mr. Alvarado will come back up.
Thank you, Your Honor. Now, Mr. Whitney, I'd like to talk to you about the survey that your analysis was based upon. Do you believe that your survey asking about CBD or cannabinoid products is applicable to the hemp industry?
I do.
And why?
Because a lot of the intermediary products, for example, that are impacted by this are cannabinoids. And so they make up the product types and the like. And so, and hemp produces CBD, which could then in turn be converted into other THC products. And so I included cannabinoids or THCA and THC Delta-9 within those cannabinoids definitions.
Now, did you use those same survey results to conduct an economic impact analysis for other states?
Yeah, I did.
Now, the AG's office raised a couple of good points, right? That you're providing averages and you're providing estimates in your report. Have you had the opportunity to look back and confirm if your economic analysis of the hemp industry was actually accurate?
Yeah, I did a analysis of the potential impact in Virginia, for example, of the change in the rules. And I made some predictions on the number of businesses that would remain versus the ones that would go out of business and the like. The number of remaining businesses I calculated at 18.4%. I then did a post survey in Virginia after those laws were signed into law to see what the actual results were to verify if my predictions were accurate. And instead of 18.4%, it was 18.25%. And so highly accurate. And so we feel that our predictive models, based upon those surveys, have a high level of confidence in their findings.
And are you confident in the accuracy and the usefulness of the survey results?
Absolutely.
Now, I believe they made some good points that you don't know all the variables the state or the agency may or may not have considered, right?
That's correct.
But there were several statements in the proposed rules where DSHS said something along the lines of, we don't have sufficient data, right?
That is correct.
And so what does that agency statement mean to you about what variables the agency did or did not consider?
They said that it doesn't give any clarification on what methodology or assumptions were used. They just say that they had insufficient data.
And now, for the public cost section, you explained that the agency did consider variables such as the cost of the increased fees and the cost of complying with the age restrictions, right?
Yes.
Based on everything you saw in the rulemaking process, do you know if the agency considered any other variables?
No, they didn't articulate any of that.
Now, have you seen what impact the proposed rules had when they were published in December of 2025?
Yeah, it created a lot of uncertainty, and there was a decline, and that uncertainty means increased risk for business operators, and so there were people that exited the market completely. That's why there was that reduction from 2025 to current at the retail level. So that's already starting to show the effect.
And that was based off of the proposed rules that were published in December of 2025?
Just on the proposed rules, yes.
Now, is it up to you or to the agency to determine how much it'll cost to administer this program?
It's up to the agency.
Okay. And how much did the agency say it would cost to administer this program?
Well, they really didn't, except for the fact that there would be an increase of $69,000 in 2026.
And again, to be clear, the agency is not going to be generating $200 million of revenue because that was based off the older fees.
Correct.
How much revenue is the agency going to generate based off of the fees in the final adopted rules?
I think I had calculated that at $43 million.
And based off everything you saw in the rulemaking process, would that be enough to cover the cost to administer the program?
It would be more than enough.
Now, you were asked questions about a 2-year inspection cycle that would be required under this program.
Yes, I was.
Was that 2-year inspection cycle mentioned anywhere in the rulemaking process?
No.
And did DSHS say, we actually may have to hire additional full-time employees if other conditions are met in the future?
Yeah, I didn't see that, they said that there would be an impact, but they didn't go into any detail.
And in fact, in the growth statement, the agency said that they were not anticipating any additional full-time employees, correct?
Yeah, and so there's a contradiction. And so between, needing to add employees and inspections versus no headcount impact at all.
And did the public have enough information to evaluate the economic impact of the proposed rules?
No, they didn't.
And why not?
Well, because they only had the costs of the fees, and then they didn't consider any of the other items that I walked through earlier. And so there's a lot more costs than what was being communicated to the general public.
Thank you. That's all I have.
Thank you, Mr. Alvarado. Anything else?
No, Your Honor.
Okay, thank you. You may step down. Yes, let's call the next witness.
Plaintiff's call Lauren Bridges.
All right, Ms. Bridges, come on up. It's a little tricky going on there. Good afternoon. Raise your right hand for me. Do you solemnly swear and affirm under penalty of perjury that the testimony that you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated. Look up at counsel when you're ready so he knows to begin.
You ready? Would you please state your full name for the record?
Lauren Bridges,
Could you spell it, please?
Lauren, Bridges, Bridges.
Ms. Bridges, where do you currently reside?
Longview, Texas.
Longview, Texas. You drove all the way from Longview?
Yes.
You prefer Lauren or Miss Bridges?
Lauren is fine, thank
You a
you.
little nervous? You okay?
I'm nervous, but it was good.
Oh.
Thank you.
Okay. And you reside in Longview. Is that where you work?
Yes,
And that's out in Northeast Texas?
it is.
And where did you grow up?
I grew up about 30 minutes from Longview out in Laneville, Texas.
Okay, so you're East Texas through and through?
All the way.
All right. Did you go to university somewhere?
I did. I went to the University of North Texas and studied fashion merchandising and design.
Okay. And when you were finished, and that's in Denton, correct?
Yes.
And when you're through with your school at the University of North Texas, did you go back to East Texas or did you stay in the Dallas area?
I went back to East Texas.
Okay. And so how long has that been?
I've been back in East Texas since 2007.
Okay. I didn't mean to date you there. but
Yeah, no, that's okay.
you have your cosmetology license?
I do.
Okay. Are you currently a hairstylist engaged in cosmetology?
I do, and I'm moving more into like the salon ownership role. But yes, I'm still hold a cosmetology license. Yes,
Okay. And do you have a salon there in Longview?
I do.
And where in Longview? Is it on the square there?
The salon is not on the square, but our other businesses.
Okay. And you previously executed a written affidavit that's attached to the plaintiff's first petition and then an amended petition. Do you remember doing that?
Yes,
Do you stand by the statements in the affidavit?
I do.
Just like you stand by your statements today?
Yes.
Is anybody paying you or make you come here?
No,
You
sir.
came here your own volition?
Yes.
I want to talk to you about your experience in the hemp industry, okay? And first of all, can you tell Judge Lytle about any certifications or any kind of schooling you have in that area?
Yes. In 2020, I went back and studied at St. Louis University. I studied cannabis science and operations. Cannabis science and operations at St. Louis University.
Okay, and is that a certificate program?
Yes, it's a professional certificate program.
And why did you do that?
I was very interested in the industry. I had some health problems, and when I learned about hemp, I wanted to learn more about the science behind it.
Okay, so you wanted to educate yourself as to the hemp industry and the science behind hemp, is that right?
That's right.
Okay. And you mentioned that you had some health problems, and I don't want to get into that. But did you have experience in what people call the teacup program in Texas?
I did. That was my first experience, yes.
Okay. And could you tell the judge what the teacup program is, even though she probably already knows?
To the Texas Compassionate Use Program, Texas's medical marijuana program.
Okay. And so you had some experience with that, and then that led you to want to become more informed?
Mm-hmm.
Is that right?
Yes.
Okay. And could you tell us a little bit about what was it about that experience in the teacup program that wanted you to become more informed without getting into your whatever health issues?
Yes. The limited access, I'm someone, I really want to know the source of where anything that I consume is coming from. I just like to know. And with the medical program, I wasn't able to find specific cultivars or what I think we call strains of certain hemp. Yeah, I like hemp products, and I felt like the medical program, it was not diverse enough. It was expensive. And, if you wanted gummies that were sugar-free, or there just wasn't a lot of options and the expense of it.
Okay. And at some point after you became certified through the program at St. Louis University, did you at some point decide to open up your own business in Longview?
I did. We started in the salon, yes.
Could you tell the judge a little bit about, so in 2020 you had a salon there in Longview, and did you change the business model? Did you do something different? Can you tell us about that?
Yes, we when we were able to do the hemp retail license, we added on that to the space in the salon, a place where I could sell the consumable hemps that were products that had become available through hemp legalization in Texas.
Okay, so out in Longview in East Texas, you have a salon, and you branch into a new area other than cosmetology, and you start selling hemp products. Is
Yes,
that right?
that is correct.
Okay. And was that around 2020?
Yes,
And did you secure a license in order to do that?
I did.
Okay. And is that salon / hemp operation, is that in business today?
It is in business today.
Okay. And what kind of license did you pay for and obtain in 2020?
The Texas retail consumable, the Texas retail license,
Okay. Approximately how much was that?
$155.
Okay. And have you had that license in place consistently since 2020?
Yes,
And about the same price, or was it?
it's
did it-
about $155 a year. Yes,
Okay. And under the new illegal rules that have gone into effect, what's the price increase?
5,000
Okay. Substantial?
definitely for us.
Put a dent in your, if you have to pay that, is it going to put a dent in your economics of the business?
We would probably close that location. It's just it's not big enough for that. Right now it's perfect, but
Okay. And I'm going to come back to that. Could you tell the judge about any other licenses and any other operations you may have other than the salon / hemp operation?
yes. So our salon space became limited, and we do have other people in there working. So I wanted to expand that part of the hemp part of the business. So I secured a location downtown Longview on our square, and so we have that there. And when that space became available, it's very big and really cool, interesting space. I went ahead and applied for the manufacturing license, and then the Texas Department of Agriculture hemp growers or producers license. And then we actually got 2 of those. So we've got 2 retail licenses, 2 grow licenses, and 1 manufacturing license currently, as well as 1 pending.
Okay. So you have the salon / hemp space. You have another retail space on the square in Longview, Texas.
Yes,
And this is not some hippy dippy Austin square. This is in good old East Texas, right?
definitely.
Okay. And I'm going to talk to you a little bit more about the kind of people who come into your shop in a minute. But so let's talk about the licenses that you've secured through the state of Texas, excluding the license that we just discussed with respect to the salon / hemp business. Okay. So this second retail location, would you tell Judge Lytle what kind of license through the state of Texas you have secured?
Yes, for that location, we had the hemp retail license, and then we had to get the consumable hemp product license, which is the manufacturing license, and then the Texas Department of Agriculture hemp growers license.
Okay.
Producer.
So the retail license for the second location on the square in Longview, is that the same cost as the other license that you just described for the salon / hemp?
Yes, $155.
Okay, and that's the one that's going to go up to 5,000 under their illegal rules.
Yes.
Okay, and the manufacturer license, you have secured that for this other location as well.
Yes.
And what's the cost of that?
$250-ish.
Okay. And what are these illegal rules going to do to the cost of that one?
That one will be $10,000.
Okay. It's going to put a hit on your bottom line?
Very much so.
We're going to come back to that. Any other licenses that, other than those that we've discussed, that you've secured, or any other locations?
Not for the hemp industry, no.
And could you tell the judge why it is that you have I'll call it a grower's license for this second retail location on the square in Longview?
I wanted to be able to grow the plant, process it, and create my product. I do topical products specifically for hair growth and a little bit of pain cream, but I wanted the community to be able to come in and see the plants being grown, see them being processed into the oils. I do solventless extraction, and then being made into a product that they could then purchase.
Okay. And are those 2 businesses, those 2 locations in operation as we stand here today?
They are.
Okay. And legal, you have all your licenses, doing all the things you need to do. Is that right?
That's right.
Okay. And have you personally reviewed and educated yourself with respect to these rules that went into effect on March 31st, 2026?
Yes, I have.
Okay. And as you sit here today, without going into a whole lot of detail yet, if those rules, if the judge does not sign a temporary injunctive order, then those rules go back into effect and you have to pay those fees. Just briefly, what's that going to do to your businesses? The two businesses that we just discussed.
They will most likely close. We are looking for a path forward, but I mean, that's for us, that's a huge increase. We're looking,
Okay.
big increase.
How many employees do you have?
We have 4 total employees.
Okay. How many part-time, how many full-time?
2 full-time, 2 part-time.
Okay. And what's the name of do you operate under a business?
Alchemy TX.
Alchemy TX. And Alchemy TX is a plaintiff in this lawsuit, is that right?
That is correct.
Okay. So do you operate under that business with respect to those 2 operations?
I do.
Do you have any other operations?
No.
Okay. And would you tell the judge, just give us a sense of the kind of products, hemp products that you have in those 2 locations?
We have topical hair growth serum. We have topical pain creams, like a beef tallow cream. We have tinctures, gummies, drinks. We have a little bit of everything that's legal and able to be sold.
Okay. And so you've got a pretty visible location, the one on the town square in Longview, is that right?
Yes.
How many people in Longview? Give us a sense of that.
We have about 80,000.
80,000. Well, it's bigger than I thought, but is that the kind of town where you kind of know everybody at least a little bit?
Yes.
Okay. Could you give us a sense of the kind of customer or person that comes into, for instance, the store or the retail location on the square? Just give us an idea.
Yeah, so I ran some analytics, and our average customer for a certain time frame that we had was around 54 years old. Most of the people who come to my store are new users, are very green to the hemp industry. They're curious. Most of them are educated. They come there looking. They know we're a CBD store or a hemp retailer, so they're coming, they have questions. But most of them are very new to the industry, and my client tends to be older, looking for pain relief, looking for, women with like perimenopausal symptoms, just people looking for relief, I would say.
Okay. So you said you ran some analytics, you thought the average age was about 54, right? And describe some people come in looking for pain relief, help dealing with other physical, medical issues, sleep issues. Is that one?
Yes, sleep.
Okay. Do you have a veteran population that visits your retail locations? Can you talk to the judge about that?
We do. We do have a large veteran population in East Texas, and we do have a lot of people coming in for that.
Okay. And, talk to me about your relationship with law enforcement in Longview. Do you have a relationship with law enforcement?
We do. Being on the downtown square, we have an officer that is assigned to us, and we have a great relationship with him. That officer comes by weekly. We talk about the rules and regulations. We talk about what's going on in the city as related to hemp, any issues that they're having on their end, and they give me pointers and tips and things on how to make their, not make their job harder while allowing me to do what I'm legally and, able to do with the selling our hemp products. So we have a great relationship.
You describe it as a collaborative relationship?
I do.
Okay. Are you a member of any downtown organizations?
I am. I'm on the Downtown Longview board. I serve on that. I've been on that for about 3 months now, and my role within that is community collaboration. That's my actual role.
Okay. And do you consider yourself an integral and important part of the community?
I do.
You consider yourself a helpful participant in the community's goodwill?
I do.
Do you manufacture some of your own products?
I do.
Okay. would you ever put, and have you ever put anything on the shelves in your store or sold anything to any of the customers that walked in your door that you didn't think was less than safe?
Never.
Okay. And do you take pains to make sure you follow the law?
I do.
Do you follow the law?
I do.
Do you, in the manufacture of the products that you sell, do you make an effort to prioritize purchase from Texas growers?
That is a very important aspect of my business.
Why?
I love Texas. I mean, Texas through and through. I believe that we should use what's more local if possible.
Okay. And do you do that? I mean, do you purchase?
That's the goal. Every product, every sale, every formulation, that's the goal.
Okay. And so you have products that, would you describe the products that you sell as intended for wellness and health?
Yes.
Okay. And is that how, in your interactions with your customers that come in and visit, is that how you're perceived in the community, as far as you know?
I believe so.
Okay.
Yes.
Okay. Now I want to talk to you about your the people that come in and your interaction with them and your discussions with them. Do you make an effort to educate your customers in the context of their purchase of your products?
I do.
Okay. Tell Judge Lytle about that. I mean, what does that mean exactly? I mean, it's easy to say, but what does that really look like?
So we have in a little, what we call the knowledge nook. We have a little space within our store where I have all kind of textbooks. I'm always looking for the newest studies on all sides of cannabis and hemp, not just the positive ones. I want to see all the new studies that come out, not just from America, even from all over the world. So I try to give access to the clients. I try to collect and all the information I can collect so that I can guide them and they can make those decisions for themselves if what's going to be great for them. I provide a lot of resources for them to take to their doctor's offices on like how to talk to their doctor about this and how to just have all the education in front of them so that they can make the best decision for themselves.
Okay. And does that happen on a daily basis?
With every sale.
With every sale. Okay. And you explained a moment ago that if these illegal rules go back into effect and these licensing fees increase, you may have to shrink or go out of business. Is that right?
Definitely have to at least shrink. I mean, we're looking at it at least, but I would say that we couldn't sustain long term under the new proposed rules.
Okay. What if, in addition to those fees, okay, let's talk about the products themselves, the products that are that may have to come off the shelves. What is that going to do to your business?
The topicals coming off the shelf would be detrimental to the manufacturing part of our business. That would be no longer. The hair growth serum that we're working with has THCV. And in my research, I found that THC actually slows hair growth down. So when we talk about some of these new regulations and we talk about heating up something and it's going to get rid of a product that was never intended to be used in the way that it was, that the testing would make it not viable. That was a lot of hard work and research I started in college to now.
All right, well, let's talk about the absurdity of some of this. So the bath bomb, you heard that as an example, the serum or the ointment. Do you know of any of your customers that are buying that stuff, heating it up and smoking it or snorting it or doing something nutty like that?
No.
Okay. Is that what these products are intended to do?
No.
Okay. We talked about what is going to happen potentially to your businesses, your locations if these illegal rules go back into effect. But let's talk about the people who visit your stores. You said they're like my age, mid-50s. They have mental or not mental, but health problems, health issues, perimenopause, menopause, sleep issues. What else? To give us like 2 or 3 more examples.
Yeah, arthritis, the sleep. There's a lot of formulations out now that could be good for focus. I have a lot of people wanting to work on their focus, work on just general wellness and health. And
You said general wellness and health. What about people who are trying to find an alternative to alcohol, for instance?
so the drinks are our biggest sector at the moment. So we have a lot of people who are coming in that don't want to drink alcohol for different reasons and for whatever, and they're experimenting with the drinks. And the drinks have been really well received. When we have local downtown events, people are always coming into the store to buy them, to be able to consume them and not go grab a beer.
Okay. It's a big question. I mean, and maybe you know the answer, maybe you don't, but these illegal rules go back into effect. Your store closes, your customers, they're going to stop?
I don't believe that they will stop. My customers have informed me, and this is them saying this, not me, but a lot of my customers are under the impression that they'll just be able to order the products that I sell online and have them shipped to them.
Okay. Or the black market?
Or the black market.
Okay. And you ever had any general discussions with law enforcement about that sort of thing?
I believe that law enforcement, yes, I have. And I believe that the law enforcement, that like the way we handle it in Longview, what they've asked me to do is when someone purchases a product, I give them a receipt and I tell the customer to maintain that product in the original packaging. And I think it makes in my opinion, and the conversations I've had, that makes law enforcement's job easier. It makes people feel more comfortable with their purchase. And then if they have any issues, they have the proper packaging with all the right labeling. They have that receipt with my store number on it. I just feel like people feel like it's safer and more like not black market.
Okay. Now let me ask you this. So I'm telling you, it took me a long time to figure out this testing and what's new and what's different and how it all works. And it's not easy necessarily, right? Unless you've lived with it, and I've lived with it some, and so have you, to a degree, right? Does it make sense to you what the state of Texas is trying to do? Does it make sense to you?
It does not make sense.
Just in layman's terms, if you could, would you tell Judge Lytle, from a business owner perspective, from somebody who lives in East Texas, as an active member of the community, tell Judge Lytle why it just doesn't make sense to you, Lauren.
I believe that the fees are, I'm someone who likes to see data, and I don't see what these increased fees or what is that going to provide for the community or for my business. And the testing standards specifically too, I don't really understand why we're taking an agricultural testing standard and moving that into the manufacturing side. So we're taking a 30-day, the test that's supposed to be administered 30 days before harvest, and now we're applying that same standard to, the finished product, which has not been the case. So for me, it's just not understanding. And as someone who has have a certificate in cannabis science and operations, who's been working around this industry since 2020, I don't understand how, I'm just confused on how this is supposed to benefit not just business owners, but how does it benefit the community?
Do you have an understanding of how this is supposed to benefit Texans?
Not at all.
Do you have an understanding of how in the world this is supposed to benefit Texas business owners?
Not the policies we're talking about today, no.
Okay. What are you seeing in the marketplace with respect to these? When I say the marketplace, I'm really referring to customers. What are you seeing and hearing from customers and members of the community about these new rules? What are you hearing on the street?
They're afraid. I think the best word I could use to describe it is many of my customers are afraid because they don't want to lose. My customers don't want to lose safe access, and my customers don't want to lose legal access. So I think fear is, something that's really coming up a lot. I mean, I have a lot of people who coming in tears, they don't know what to do. They're afraid of what's going to happen to the business, and not just my business, but what's going to happen to them when they don't have this safe legal route to purchase the products that are really benefiting them.
Are your customers scared that they're going to lose access to products that help them?
Yes,
Do you believe that fear is well-founded?
I do. If these rules and regulations were to go into effect, yes.
Okay. Do you share that fear?
I definitely do, yes.
Is that why you're here?
Yes.
Pass the witness.
All right, thank you, Mr. Snell. You may proceed. And tell us your name for the record.
My name is Keith Ingram. I'm with the Attorney General's office. Ms. Bridges, just have a few questions. So you sell health and wellness products primarily?
Yes.
And that includes a lot of topical ointments and creams and hair growth serum?
Yes.
But you also sell what I would call more recreational edibles, such as drinks and gummies and that sort of thing?
I wouldn't call them recreational, but I sell those products, yes.
Okay. And one of the products that you sell is hemp flowers, is that right?
Yes.
And what do you expect customers to do with hemp flowers?
I have a lot of customers who make it into tea. I have a lot of customers who, I have some very interesting customers who they love to create their own products at home. So yes, but tea is a big one for us though.
Okay. Do you expect any of your customers to roll it and smoke it?
I'm sure some of them do, yes.
And are you familiar with the THC content in your hemp flowers?
Yes, I am.
What is it?
Below 0.3% THC.
What I understand the THC is going to be below 0.3, but what is the THCA content?
The THCA content, it would be listed. I mean, I believe on most of our products, if not all of I only carry a couple of brands of flour. I'm very selective in that. So all of that would be included in the COA.
Okay, and you keep the COAs in your business?
Yes, and on the product.
Okay. And do you have an idea of how much THCA content is in your hemp flowers?
I'm not right this second, but we could access it easily.
Okay. Is it posted on your website?
Each product should have a COA link to it. Yes, sir.
Okay. And do you have any idea how much THCA is in your topicals or your hair serum gel?
I don't, not off the top of my head, but I do know that keeping the THC level low for the hair growth serum is very important to us. So the THCA would probably be high because we do not want that to be converted into THC because it would be counteractive to the
You
hair
manufacture your own products, isn't that right?
Yes.
And do you get those products tested for THC after you manufacture them?
Yes.
And do you have the certificates for those manufactured products?
Yes, I do.
So if we wanted to look at the levels of THCA in those products, we could?
Yes.
And it's already been tested?
Yes. If it's available for sale, it's already been tested.
And so the requirement to test for THCA is not going to be a new thing for you?
I test for everything. So there's no new requirement as far as I'm a nerd about it. I want to know everything about the product. And if I'm creating the product, then yes. But as far as what is legal, like what we have to do legally, that will be different for the THCA, I believe.
When you educate your customers, do you talk to them about THCA content?
I do. I do speak with them about all the cannabinoids that whatever they're purchasing includes.
And what do you tell them about the THCA content?
THCA as I show them the studies of what THCA has been, proven to do or not do. I show them, the education that we have available in our Knowledge Nook.
And do you tell them that if they were to light a hemp flower on fire, that it would increase the THC level?
I don't typically have to instruct people on how to do that if that's what they're going to do. That's not the majority of our customers.
I understand, but is that something that you educate your new customers who are new to the business about?
That hasn't come up with any of our customers for me to educate them on that.
Okay. I think that's all I've got.
All right. Thank you, Mr. Ingram. Mr. Snell, anything further for this witness?
Very brief, Judge. these businesses that you've described, this is your life's business. This is your work.
Yes.
Okay. Goes out. These businesses go out of business. That's a big deal to you economically.
Very big deal for me economically.
Devastating.
Devastating. It's what sustains me and my family of 4. So.
4.
Mm-hmm.
Kids?
2 kids. Yeah.
Ages?
2 and 16.
Okay. Devastating impact on your family?
Yes.
Okay. The products on your shelves that you manufacture, what's going to happen to those products? This illegal rules.
They'll no longer be available.
Destroyed?
Yeah, no longer available.
Okay. Gone.
I'm sorry, you're answering?
Yes. Yes.
Pass the way.
Mr. Ingram, anything else?
I just want to make sure I understand your testimony. Did you just tell plaintiff's counsel that every product in your store is going to be outlawed with these new rules?
The 2 topicals that I manufacture, yes.
How do you know that?
Because when you heat those products up, and for the end, like the THCA will convert to THC with the heating process of the total THC. Those 2 specific products, yes.
Okay, that's what I got. Thanks.
I have nothing further, Judge.
All right, you may step down. Thank you for your time. All right, let's call the next witness.
And Jason, I'm going to call Brian right now. I'm going to call Brian Swenson from Idaho.
We'll go for about 15 minutes before we take a break, but Ms. Pallas, is that okay?
I prefer not, if you don't mind.
You prefer now? Okay. We're going to go ahead and take a 15-minute break now. Go ahead and get your next witness ready. All right.
Yeah.
All right.
You got some great people. You got some great people. What do we do right now? Just think about how.
Okay. I hope everyone had a good break. Let's, Ms. Pallas, you ready? Back on the record on D1GN 26002511. Let's call your next witness, please.
Your Honor, plaintiff's call Brian Swenson.
All right, come on up, sir. You're gonna go around the court, reporter. There is a ramp going up. Sometimes that can surprise people, so just look up for a little ramp.
Thank you.
Raise your right hand. Do you solemnly swear and affirm under penalty of perjury that the testimony that you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated.
Good afternoon, Mr. Swenson. Can you please spell your name for the record?
Yes, it's Brian, Brian, last name Swenson, Swensen.
And Mr. Swenson, can you please introduce yourself to the court and tell us about yourself?
Yeah, hi, I'm Brian Swenson. I'm currently serving as the Executive Director for Hemp Industry and Farmers of America, otherwise known as HIFA.
And what is HIFA?
HIFA is an organization that is comprised of advocates for the hemp industry, and it includes business owners who represent every element and every part of the supply chain for the hemp industry. We advocate on behalf of consumers, of employees, so anything that falls under the hemp industry, we advocate on behalf of.
And what is the purpose of HIFA?
The purpose of HIFA is to advocate for good regulatory structures and changes made for the industry. We advocate for consumers to make sure that they have access to the various products that they would like to. We advocate on behalf of employees to make sure that they have jobs that they're able to go to day in and day out.
And is that one of the reasons why HIFA is one of the plaintiffs in this lawsuit challenging the agency's new rules?
Absolutely.
And does HIFA include members from Texas?
It does. Correct.
And is it important for you to understand what's really important to members of the Texas hemp community?
Of course. Yes, I spent, I think it's something to the tune of about 50 nights out here last year, meeting with various business owners, legislative members as well. That was a big part of it. And I learned a lot from the folks here in Texas. I've met several farmers, a lot of business owners, and many of their employees. I was here in town last year for two of the hearings that were done on the House side, where multiple folks across the state of Texas came in to testify in favor of putting forth good regulatory structure that HIFA proudly stands behind.
And have you observed the ways in which the agency's new rules have impacted members of the Texas hemp community?
Yeah, I have. I have observed firsthand from a number of the folks that give to HIFA because of the regulatory changes that were, the illegal regulatory changes that were put in place by unelected officials. We saw funds drop off because a lot of these store owners were not able to sell products that they typically otherwise would. One of the gentlemen I spoke with earlier this week, he was telling me how.
All right, any response?
I'll rephrase the question. All right.
Why don't you go ahead and give the instruction on hearsay as well?
Okay, so Mr. Swenson, while you were able to testify about things that you've observed, what we don't want you to testify about is what other people have told you. Because they're not here to testify, be cross-examined. Does that make sense?
Understood.
Okay, so let me rephrase my question. Have you observed the ways in which the agency's new rules have impacted Texas businesses?
Have I observed the ways? So I can't use an example of a business owner telling me he laid off.
So not what someone's told you, but have you seen the impact of these rules on any particular Texas businesses?
Do you have personal knowledge?
I have not physically seen people laid off and not working. If that appropriately answers the question. What I have seen is commitments of contributions that I use to advocate for the industry and to advocate for regulatory structures not be fulfilled because those individuals needed to save funds.
Okay. And do you personally know why those individuals are saving funds rather than continuing to support HIFA?
Yes, they're saving funds because they are not making as much money as they were up until the latest injunction.
Now, how have members of the Texas hemp industry reacted to these agencies' new rules?
Well, on one hand, positively when it pertains to implementing of 21 plus and no marketing to children. Those are very good and common sense rules that the state had made. However, some of the other rules, such as the fees, very high. That was a number. That was one of the complaints that I received from a number of our members, as well as especially when you look at guys that have multiple stores, they're going to be putting in even more funds that could otherwise be spent elsewhere for salaries or things like that. And then there's also the testing standards. That also has created a number of problems amongst our guys, as well as them having to no longer carry certain product lines.
And what is HIFA's position on the agency's new rules that would add new testing requirements and new compliance standards for the hemp industry?
We don't support them.
Okay, and why not?
Because it's removing multiple product lines. It is causing for businesses to no longer have the high volume of sales that they typically would have, and that in turn is causing the letting go of several employees.
No further questions.
All right, thank you. Counsel, you may come up.
Allie Thorburn for State Defendants. Good afternoon.
Hey.
I just have a few questions for you.
Shoot.
Okay, you said you are with HIFA?
I'm sorry?
You're with Haifa.
Yes,
Okay, and Haifa was organized in 2025.
correct.
And you advocate for the hemp industry?
Yes.
So you advocate for people to keep their jobs in the hemp industry?
I advocate for good regulatory structure and changes, just like I did last year when I was here in Texas when we were asking the legislative body, to push for 21 plus, no marketing to children. We were even in favor of school zone requirements.
And on direct, one of the things that you said was you advocate for people to have jobs in the hemp industry.
Yes,
And you advocate for consumers.
correct.
On direct, you didn't mention that you advocate for the health and safety of consumers, correct?
Well, no, but that is
You didn't mention that on direct, did you?
positive regulatory changes. Yes, I did.
You did not say the words, we advocate for the health and safety of consumers.
I did not say those words directly.
You said that you advocate for consumers to get the products they want.
I did say that.
I want to talk about those products. So you said that these rules may require some stores to remove some products, right?
Correct.
And those products would be the ones which have a THCA content that's too high, right?
Correct.
Okay. And THCA, when it's heated, converts to THC, correct?
Yeah,
And THC is what gets you high.
it could.
When burned or when heated, THCA converts into THC at a rate of 87.7%, correct?
Sure. Yes.
And a lot of the companies that Haifa represents, they already do that testing, right?
The testing is done when when hemp is when the crops are harvested.
But you're aware that a lot of the sellers already have THCA testing, and they advertise it on their websites.
I'm sure they do. I have not looked at any of their websites.
Regardless, your organization advocates for people to get the products they want.
The products they want, and for those that require it for various ailments and reasons, we absolutely advocate for that as well.
And the ones that will be removed are the ones with a THCA content that will get them high.
That would include topicals and things that we just previously discussed, right?
It would also include pre-rolled joints,
Okay.
correct?
Yes.
Edibles.
Edibles. Yeah. We have consumers that require access to have edibles because they have chronic pain and they need to sleep at night. One of our consumers, her name is Meemaw, and we've had her on some of our member calls.
You're aware that there are medical exemptions for medical marijuana, correct?
There are medical exemptions for products that are sold much higher than what they can purchase in consumable hemp stores that are made federally legal.
You want people and consumers to be able to purchase the products they want.
I want people to be able to have access and the choice to purchase products that they may need for various ailments or that they want.
And the products that they will not be able to purchase now include, under the new rules, at least the ones, maybe not all, but at least some, that will get them high.
That is a possibility with the illegal rules that were made by unelected officials.
Pass witness.
All right, thank you. All right, Mr. Alvarado.
Now, Mr. Swenson, I apologize. I forgot to ask you this question. Is health and safety of consumers something that's important to Haifa?
Oh, absolutely.
Okay. And is that something that Haifa advocates for?
It does. We have been on the record in the past about talking about making sure that there are no toxic metals or pesticides in the final product.
So why is it important to Haifa for people to have access to consumable hemp products?
It's important for consumers to, be able to have a choice and get access to the products that they need. I mean, I've spoken with countless veterans all across the country and here in Texas that have chosen to use consumable hemp products in lieu of opioids, which are more addictive, and in lieu of alcohol.
And why is it important to HIFA that people have the choice for how they choose to treat those ailments or treat those issues?
I think it's important because, number one, I mean, people are able to get immediate benefits for utilizing these products. Their quality of life goes up. They're able to sleep at night. I've spoken with countless seniors who have chronic pain or are recovering from cancer, or insert ailment here. I mean, there's multiple reasons why a lot of consumers would like to have access to these consumable hemp products and be able to access them in a convenient way, such as walking maybe 5 blocks if they don't have a vehicle, or going down the street to a store where you do have access.
And does HIFA believe that the agency's illegal rules, if they're allowed to go into effect, would limit?
Objection, Your Honor. Characterization of the rules.
Overruled.
So, Mr. Swenson, if the agency's illegal rules are allowed to go into effect, how would that impact consumers' access to products and their choice of what products to use?
I think what you'll see are, number one, a number of product lines get removed from shelves, such as lotions and topicals and things like that. You're going to see business owners, and one example I can use is one that told me he temporarily had to, I can't talk about that one.
Not what they told you, but.
Yep. But you're going to see stores close. You're going to see access diminish. And you're going to see prices increase because of the fees.
That's all I have. Thank you.
All right.
Nothing further.
All right. Thank you, sir. You may step down.
Thank you, Your Honor.
All right. Let's call the next witness.
And Your Honor, plaintiffs call Mitch Fuller.
All right.
So this is ready for you.
Good afternoon.
We'll say, I'll show you the exhibit.
Is the pharmaceutical cocktail and alcohol. That's as clear as I can state it.
Now, I appreciate you being vulnerable and showing how these hemp products have affected you personally. But now I want to talk about your role as the national and state legislative chairman for the VFW. Now, can you tell me about the veteran community here in Texas?
There are 1.5 million veterans in Texas. As I said earlier, we have 65,000 members in the VFW, plus about 20,000 members that include our family members, our spouses, children, grandchildren. So that's about an 85,000 member family. The VFW was founded 126 years ago for legislative advocacy. That was our primary mission from the start when we were founded. So that remains our primary mission, and I take that seriously. Again, I've been in my position for 5 years. Legislative advocacy is a relationship business. Legislators have to trust us, me, to represent. They know that I represent the VFW, and they know that I speak for the entire VFW. I speak for our commander. I speak for our entire membership when I talk to them.
Now, do you have an understanding of how many veterans in Texas are living with a disability?
It's thousands.
And what are your primary responsibilities as the legislative chairman for the VFW? What do you do for the community?
The VFW is a member-driven organization, so our legislative priorities are determined by the delegates to our national convention, and in Texas, they're determined by our delegates to our state convention. So the legislative priorities that I draft for approval by our leadership and our membership will be approved for the forthcoming session in 2027 by the delegates at our state convention in June in Dallas.
And how do you know what's important to the veteran community in Texas?
It's a two-way street. We're grateful that we have broad support, bipartisan support in the legislature, so we know what's coming out of there. So I will anticipate being invited to testify in the interim session in the House and Senate committee hearing. So you know what's coming out of the legislature. The relationship with the Veterans Commission and the Veterans Land Board.
The
Veterans Land Board. The Texas Veterans Land Board. Yes. But more importantly is listening to our members. What are our members' concerns? And this issue today is a primary concern. It was the top concern in the 89th legislature. So I listen to my members. I get approval for the legislative priorities that I draft based on what I'm hearing from the legislature. And then relay advocate for the VFW in front of the legislature for those priorities.
So it sounds like, and forgive the pun, but you kind of wear two hats in their role.
Sure.
And one role, you're informing the veteran community about what issues the legislature is considering. Is that right?
That's correct.
And the other part of your role is informing the legislature how the veterans feel about the issues that they're considering.
Absolutely. And counselor, there's three types of testimony before the legislature, essentially. Public, where you sign up for 2 or 3 minutes and you get in line and you wait. And sometimes you wait a long time. Asked, offices frequently will call me to ask me to testify. The best one is invited, because when you're invited, you're at a panel and you're considered an expert, a subject matter expert on the issue. So I have credibility. This hat, this cover, which we've worn for over 100 years in the halls of Congress and in state legislatures, that's the credibility, that's the trust. I have those relationships on our behalf inside the state capitol on our issues that are important to us.
And have you been invited by the state capitol to testify about this issue?
Frequently.
And do you have an understanding as to why you were invited to testify?
Well, the 89th session was my third session in a full-time capacity, so that the people know who I am, especially the veterans committees. But in the last legislative session, I testified before 14 committees of the legislature, 10 in the House and 4 in the Senate. Not all veterans bills matriculate through the Veterans Affairs Committee. There are bills that benefit us that are in other committees. Senate Finance Committee, which is the budget for the, as an example, for the Texas Veterans Commission.
I'm going to ask you to slow down. I'm very sorry.
No problem. As an example, the Senate Finance Committee, which is the budget for the Texas Veterans Commission, the Public Health Committee. So there's, again, 14 different committees on over 40 pieces of legislation and a very broad policy portfolio.
And based on your experience, do you know if the legislature or the governor's office is interested in knowing what's important to the veteran community in Texas?
Absolutely. Myself and our leadership had two meetings with the governor's office, one in May and one in July at the beginning of the in May was at the end of the session, and in July was at the beginning of the first sessions. I am constantly contacted by offices on their advice. They may have a constituent that's filed a veteran-related bill and ask for my input on that, or ask if I would support a bill, or ask me to come testify for a bill.
And does the state capitol look to you as an expert on what's important to the veteran community?
Yes, they do.
So it sounds like it's really important for you to know what's actually important to the community here in Texas.
Yes, and it's not just this issue, Counselor. As I said, it's a broader way of issues. But this issue was the number one priority in the 89th legislature.
Now, what type of information do you consider to determine what's important to the veteran community in Texas?
You have to listen. I have to listen to my brothers and sisters. Start there. The best people to help veterans are veterans. And so that's important that I listen to what their concerns are, their personal concerns. The thing that resonates the most with elected officials in Congress and in legislatures are stories, personal stories about how issues impact them personally.
Now, is that the type of information that legislative representatives like yourself use to determine what's important to the communities they represent?
Absolutely. Yes.
And how long have you been in this role speaking with veterans to understand what's important to them?
5 years. My first day was March 1st, 2021, right in the middle of the 87th legislature.
And how many veterans have you spoken with during that time?
Hundreds. Difficult to quantify.
Now, what is your understanding of what's at issue in this lawsuit?
Well, observing this before, I watched the testimony earlier this afternoon, and the concern was what I saw on the screen here, a retailer's license going from $150 to $5,000. The concern for us is that's going to put it out of reach. That's going to put a product, these legal hemp-derived consumables out of reach for us. So if I pay $10 right now, which for about, for 10 gummies, about $40, if you project the math out and do some, take that out, those 10 gummies may cost $300 or $400 if you project that out. That's going to put it out of reach for a lot of us.
Now, do you know if the issue of the agency's new proposed rules is important to the veteran community in Texas?
It is, because it's going to limit, in our view, it's going to limit access.
Now, you spoke earlier about your involvement in determining the legislative priorities for veterans in Texas. Can you explain that a little bit more?
Yes, and again, listen, like we said earlier in this testimony, your questions, Counselor, it's listening to our members. It's knowing what comes out of the legislature. It's knowing what legislators are thinking in terms of bills. All those conversations, all those relationships add up to me having a good knowledge. When I put a draft of our priorities in front of our membership, I've got a good sense. It's my duty as a paid, you know, our lead advocate, our lead expert in the legislature, to know what they are thinking as well. Draft those, and then we have 3 major state events in our organization: our midwinter conference in January, our state convention in June, and our state training, leadership training in July. I give a report at those events every year. So our 500 or 600 of our top leaders are there with their auxiliary to hear what our priorities are.
Now, I'm going to pull up on the screen for you what's been admitted already as Exhibit P20. And Mr. Fuller, do you recognize this document?
I do. I wrote it.
Okay, and what is this?
This is our 2025 state legislative priorities that were approved by our membership in the summer of 2024.
Now, JR, if you could scroll down a little bit, that's perfect. Mr. Fuller, do you see toward the bottom of the page the paragraph that starts with advocate for increased access to alternative modalities to opioids?
Yes.
Can you explain what that means?
And that's not an exhaustive list, by the way, but these are the top 4. There are several more alternative modalities that we advocate for. The opioid and antidepressants has been the default position of the VA to give us to address our mental and physical health concerns. And that's been devastating to our community, absolutely devastating. 18 veterans committed suicide at VA facilities in the United States in 2025. 2 of them were in Texas. 2 of them. Both of them were at San Antonio, at the Audie Murphy VA facility in San Antonio. And we know that from public comments, and we know that I have a relationship with the father of Mark Miller, who was the one that killed himself in April. I've observed the absolute grief that he has. They are tied to the opioid and antidepressant, what we call the pharmaceutical cocktail, which has absolutely done a number on our community, and not just the veteran community, but all of society, frankly. And so our view in Congress and in our state capitals is to advocate for modalities that may work. Something may work for you, counselor, that may not work for me, and vice versa. This is about access to choice. And this issue today is about access to an effective, affordable, and accessible alternative, one that works. And our concern is going to be taken away from us. That's the concern that we have.
Now, Mr. Fuller, I can tell that you're passionate about this.
Absolutely.
But aside from your personal feelings about this, why do you believe it's important to the veteran community to advocate for alternative modalities to that pharmaceutical cocktail you described?
I've sat through the hearings. I sat through an 18-and-a-half-hour hearing in the House State Affairs Committee on Senate Bill 3, April 7th and 8th. It started on April 7th and it ended on April 8th. I saw the testimony. I know what I've observed from my brothers and sisters in the veterans community. I witnessed our state commander testify bravely about his story in the Senate and the House, in the Senate State Affairs Committee on March 4th and the House State Affairs Committee on April 7th. He told his story, and it's on the public record. It's archived in the committee hearings. 10 years ago, his wife found him 3 blocks from his house in his robe with his cane at the low ready. And the low ready is a weapons position that we have when we're dismounted, when we're walking, when we're in a formation. He doesn't have any memory of that. The only reason he knows that is because his then wife told him that. He's our state commander. He's a highly paid IT professional. Hemp-derived consumables have allowed him to get off of every single one of his opioids and antidepressants. He takes one other pharmaceutical. I don't recall what it is, but he is not taking any of those opioids and antidepressants that rendered him ineffective, unproductive. We pride ourselves in the veterans community. We have a hashtag in the VFW that says "still serving." We take the uniform off and we put this cover on. We are serving our community. Hemp-derived consumables is one of these alternatives on this list that allows us to do that. We don't want to be in a fog. We don't want to be isolated because that leads to suicide. We want to be productive members of society, serve our fellow veterans, and serve our community. And this what we're talking about today in this hearing is one of them that works.
And have you testified in front of the Texas legislature about this issue?
Yes, I have. There were 4 hearings last year. There were 2 in the regular session. The only reason I wasn't in attendance at the Senate hearing, the Senate State Affairs hearing on March 4th, is because I was in Washington, D.C., testifying before Congress about this, sitting next to our national commander. So I handled the question and answers from the Senate. It's a joint session of the Senate and House Veterans Affairs Committee. I handled the question that we got in D.C. from in that congressional hearing about the question of alternative modalities to opioids. 18 and a half hour hearings in April, as I said. Special session in July was a 6-hour hearing. I was invited to testify in August at the 4th hearing in the House Public Affairs Committee by the Speaker's office and by the chairman of the Public Health Committee, his office, to testify. And I had to do that virtually because I was in Columbus, Ohio at our national convention. I thought, great, I got invited to testify. I won't have to wait long. Well, guess what? I had to wait 4 hours. I was on panel number 4. So I've sat through the hearings. I've heard all the stories. I know how this affects our community. And it's not just us, Counselor. It's not just the veterans community. I have witnessed other powerful testimony as well.
Now, Mr. Fuller, I want to focus on the Texas legislature and your testimony before them. What was important to the VFW? What were the VFW's goals when you were testifying in front of the Texas legislature?
That we have continued access because we consider this affordable, effective, and accessible. It's something that works. It's been legal for 7 years now. There's a straight line between the 2018 Federal Farm Bill and House Bill 1325 in the 2019 legislative session. They have been legal, and we are not knowingly going to put poison in our body because the poison, as I said earlier, has been the pharmaceutical cocktail and alcohol.
Now, during your testimony, did you try to educate the Texas legislature about any particular issues?
It's been one of the most challenging parts of this as a legislative advocate for the past 5 years. The majority, if you go back and look at the record and you look at who signed up to testify, the large, far majority of the people that testified, not just us, but Texans from a broad variety of demographics, were opposed to a ban on this product. And that's got to be dealing with it. But the frustrating part about this, from the legislators who want a ban and the state, is they are equating cannabis into one bucket. Illegal marijuana is not a 0.03 THC level, gummy. But in the minds of many in the legislature, that is the case. And it was frustrating to watch testimony, even from law enforcement, to talk about this and equate, taking a hemp-derived, consumable from a psychotic episode, when you hear some of this testimony. And you have no idea what this psychotic episode, what caused it. Did they buy illegal marijuana with fentanyl? Were they taking something else? But the most powerful testimony I saw, Counselor, was the April 7th hearing in House State Affairs. And it was 2 little girls sitting with their mothers. One of them was in a wheelchair, and these are adolescent. They were probably 13 or 14 years old. And the importance of full spectrum CBD, which has THC in it, for them. These are little girls. I'm a parent. I have a daughter and a son. They're young adults now. But that struck me square in the heart. I know the stories that we have in the veterans community are powerful. But when I saw those 2 little girls, that was difficult to watch. That was difficult to watch.
And how did observing all that testimony impact your opinion on whether these hemp products are important to the veteran community or not?
Maybe more mission focused. I'm a combat veteran. Maybe want to fight harder.
And Mr. Fuller, in your role for the VFW, what is your mission?
My mission is to advocate for the veterans and their families. And we pride ourselves, Counselor. We advocate for all 1.5 million veterans in Texas and their families.
Now, separate from testifying in front of the elected officials in the legislature or at the governor's office, do you ever testify in front of state agencies?
No.
Like the Department for State and Health Services?
No.
And why not?
I'm a legislative advocate. I talk to lawmakers. I talk to elected officials who make laws.
Now, Mr. Fuller, can you explain and summarize your opinion on how consumable hemp products impact the veteran community.
As I said earlier, Counselor, no, we don't want to be victimized. As I said, I'm not the only one who has to live with post-traumatic stress. I am not going to let it debilitate me. We have a tool in our toolbox here, hemp-derived consumables, a modality, again, that works, that allows us to be productive, that allows us to be high-functioning. I love what I do. I absolutely love what I do. But if I was subjected to the pharmaceutical cocktail or I had to rely on alcohol, I could not perform at the highest level that I need to perform at.
And so earlier we looked through Exhibit P20, which was your 2025 legislative priorities. Your Honor, at this time I moved to admit that in the record. I may have misspoke earlier if it was
What was the exhibit number?
Plaintiff's 20.
And you can see, Counselor, that's a broad policy portfolio there, very broad.
All right, one moment. P20 has been offered. Any objection?
Your Honor, we object. It takes lots and lots of information that is completely irrelevant to the issues at hand here.
Okay, so your first objection, your objection is relevancy, correct?
In addition, we add hearsay, and again, relevance and hearsay, Your Honor.
All right, so you need to address both.
Okay. Your Honor, as Mr. Fuller explained, part of his role for the VFW is understanding what's important to the veterans community and then presenting that information to the legislature. This document shows what issues are important to the veteran community and was created as a result of Mr. Fuller's work trying to understand what's important to all of them. And so we believe it's relevant and that Mr. Fuller can rely on it to support his opinion on the narrow issue of what and how these products are important to the veteran community.
Okay, so does that also answer the hearsay exception?
Yes,
You're
Your
saying it's not being used for the truth of the matter?
No, just for the how it impacts Mr. Fuller's expert opinion on the importance of these products to the veteran community.
All right. Looks like you're standing and you'd like to add.
Your Honor, I think there's one paragraph that in this document that might be relevant to the subject at hand, and it does appear as if it's an attempt to get hearsay within hearsay admitted through this document.
The objection is sustained. But you can continue to ask questions as long as you need to.
Okay. So, Mr. Fuller, won't veterans be able to access these same products and get the same alternatives through the TCA program?
Well, as you can see, even though that's not admitted, but everybody can see it up there, we advocated for the expansion of the TCA program. But it's our view the state wants to take hemp-derived consumables away from us and force us into TCA. We have many veterans. I've observed this. I know this, who've used this program. It's got a higher level of THC than hemp-derived consumables. It's more expensive. There's less access. Yes, House Bill 46 was passed in the last session to expand the TCA program, but that's not, you can't snap your fingers and expand it. It's going to take years for that to happen. And the Department of State, I think DPS has already stumbled on the initial implementation of House Bill 46.
And Mr. Fuller, aren't pharmaceuticals effective for at least some people?
Of course, and we're not suggesting that no one take pharmaceuticals. This is about choice for us. This is about individual choice. Adults making responsible decisions on how to take care of themselves.
So the VFW is not advocating for getting rid of pharmaceuticals
Of course
or
not.
getting rid of the TCA program?
Of course not. Of course not. On the contrary, we advocate for expanding it, but it takes too long. It's going to take years to do what House Bill 46 was intended to do.
And Mr. Fuller, is there an official sort of slogan or catchphrase or talking point from the VFW about consumable hemp products? And
again, I'll say it again. I've said it a couple of times now. Affordable, accessible, and effective allows us to be productive. Allows us to be better husbands, wives, fathers, parents, friends, leaders. Anybody that's worn a uniform is a leader. And this allows us to continue to do that and continue to serve our community. And for me personally, it is personal. It's extremely personal. What's being proposed here today, and again, we're grateful for the governor for vetoing Senate Bill 3 so we can at least have this conversation that we're having. But it's frankly frustrating that we're having to keep talking about this.
Well, Mr. Fuller, thank you for your time and thank you for your continued service, and I pass the witness.
Thank you.
All right, looks like Mr. Ingram's coming up.
How about Mr. Rich, Your Honor?
Oh, Mr. Rich, apologies. Come on up.
Mr. Fuller, good afternoon.
Good afternoon.
Thank you for your service.
Thank you for saying that.
Do you need to be a legislative advocate as part of your job for the VFW?
My employer is the VFW, Texas VFW, yes.
So your job is to advocate on behalf of veterans for compensation, correct?
Yes,
So your outside of this courtroom job is consistent with your purpose and testimony here today?
yes.
You ever use smokable hemp?
No,
Have you?
no.
For the hemp products that you do use, do you keep yourself aware of the THCA quantity?
The products that I use have a barcode on them, so I know exactly I know exactly what's inside of there.
And are you aware as to whether or not retailers and manufacturers of consumable hemp products are required to disclose THCA levels?
I'm not sure about that.
Do you like to know? Is that something that you're
Of course I do.
interested
Of course I do.
in? You were successful in your advocacy for the legislature with respect to expanding the D-Cup program, correct?
Yes.
The passage of HB 46?
House Bill 46,
Thank you.
yes.
That broadened healthcare conditions for which medical cannabis may be prescribed, right?
Added chronic pain, yes it did.
Yeah, chronic pain, PTSD, traumatic brain
PTSD was a previous session, 23.
And that House Bill 46 also allowed physicians to request new and different conditions to be added, correct?
Yes it did.
Yeah. And the number of dispensing licenses has been increased under HB 46, right?
Yes, and that process has not gone very well so far.
And I think it was just last week, the U.S. government.
Descheduled, yes.
Yeah, let me finish the question, if
Sure,
you would, please.
sure.
You probably know where I'm going. 'Cause
I do.
You're involved in this.
I do.
Yeah, they changed the scheduling.
Let's make sure we keep it one at a time so I can get a good record. Thank you.
So, yeah, you're involved in this. You know where I'm going. They rescheduled some cannabis, correct?
They descheduled marijuana from 1 to 3, Schedule 1 to 3.
And so
based on the president's executive order in December.
And that's going to make access to that product easier on a medical level, correct?
That's the intent. Yes, that's the intent, yes.
No further questions.
Yes.
All right, you may proceed, Mr. Alvarado.
Thank you, Your Honor. Now, Mr. Fuller, part of your testimony today was in your role as a legislative rep for the VFW, right?
Yes.
And you are being paid to advocate on behalf of veterans today in court, right?
Yes.
Okay. Does the fact that you're being paid for that affect your testimony?
No, I'm not a lobbyist. I don't have to register with the Texas Ethics Commission. I am an employee of the Texas VFW. I'm fulfilling our mission that we were our founding principle of advocacy in 1899.
And Mr. Fuller, are you here to earn a paycheck?
No.
What are you here for?
I'm here to do my job. I'm here to do what I'm passionate about, which is to advocate for all veterans. This issue is not just some theoretical exercise in this or that. This is serious for our community. This is absolutely serious for our community.
And you also testified today in your personal capacity, right?
Yes, I did.
And is this an issue that's personally important to you as well?
Absolutely.
And
I'm worried.
And why are you worried?
I'm worried. I'm scared, and that's kind of difficult to admit in public. But I'm scared of what this could do to me, and I'm scared of what this could do to our community and the spouses for our community. We had a spouse of somebody I work with also testify. So this isn't just about veterans. It's about their spouses as well.
Thank you, Mr. Fuller.
Thank you.
Mr. Fuller, Why have you never used smokable hemp?
It's my choice. She chose not to.
Is there something you don't like about it?
I used to smoke cigarettes, so that's kind of that's a personal view of mine. But if Texans want to use the smokable hemp product responsibly, that's on them.
Do you have health and safety concerns about the smokable?
I just have concerns about my own self.
Are you aware that recently hemp manufacturers have started rapidly increasing the THCA levels in smokables?
I'm not aware of that.
No further questions.
Nothing further, Your Honor.
All right. Thank you, sir. You may step down.
Thank you.
Okay, let's call your next witness.
Your Honor, can we have a brief moment to confer?
Yes. Also, at the end of the day, I'll have some updates on what tomorrow will look like.
Okay. Thank you, Judge, we're ready to proceed.
Okay, call your next witness.
Plaintiff's called Melanie Carpenter.
All right, Ms. Carpenter. Please raise your right hand. Do you solemnly swear and affirm under penalty of perjury that the testimony that you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may be seated. There's fresh water if you need it.
Thank you.
Look up at the attorney when you're ready.
Are you ready, Ms. Carpenter?
Yeah, I think so.
Okay. Would you please state your full name for the record and spell it?
Sure. Melanie Carpenter, Melanie, Carpenter, Carpenter.
And Ms. Carpenter, where do you currently reside?
I live in Missouri City, Texas, in Siena.
In
Siena, it's a master plan community, one of the biggest in the state.
Okay. So you drove here from Missouri City?
I did.
Okay. On your own volition?
Yes.
Is anybody paying you to be?
No.
And you signed an affidavit attached to plaintiff's pleading. Do you recollect that?
Yes.
And do you stand by the statements within that affidavit?
Yes.
Now, I want the judge to get a little bit of a sense of who you are. What is your primary business?
So I have two businesses. I'm a commercial real estate broker, and I also own Serenity Organics, your CBD apothecary, with my husband.
Sorry, what was the second name after Serenity Organics?
Your CBD apothecary.
Okay. So you have two primary occupations. One is the owner of the business that you just described, and the other is what?
I'm a commercial real estate broker.
Okay. And for Keller Williams?
Yes.
Okay. And how long have you owned and operated Serenity Organics?
We opened in June of 2020, so just about 6 years.
And does that business, is that a DBA that operates under CPRT and Company LLC?
Correct. CPRT and CPRT LLC and Company is the name of the business. The DBA is Serenity Organics.
Okay. And is that a plaintiff, that entity?
Yes. Correct.
Let me finish. That's hard, I know.
Sorry.
That's okay. Is that entity a plaintiff in this lawsuit?
Yes.
Okay. And you've been operating this business since 2020, is that right?
Correct.
And who do you operate that business with?
My husband.
Okay. And what is his name?
Joshua Carpenter.
Joshua Carpenter. Okay. So you and Mr. Carpenter have operated this business for 6 years?
Mm-hmm.
Okay.
Yes.
And are you licensed through the state of Texas?
Yes.
And what kind of license?
A retail hemp license.
Okay. And cost of that?
$155 a year.
Okay. And so where is your business located?
It is, we're in Siena. It's a master plan community. So we're at the front. I mean, we're basically in a subdivision.
Okay. So if I drive into your community, Sienna, do I see, maybe to the left and the right, retail businesses?
Correct.
Things like that? Okay. And so your Serenity Organics is within one of those, I guess, retail areas?
Yes.
Okay. And you have a storefront?
Yes.
Okay. And how many employees?
Just my husband and I.
Okay. What are your hours?
It's every single day. We operate about 62 hours a week.
62,
We're open.
62 hours a week?
Yeah.
Okay.
Yes.
All right. And have you been in that location for the last 6 years?
Yes, it's our only location. It's the first location.
Tell us about the Serenity Organics. Tell us about the kind of products that it sells.
Yeah, we are a health and wellness store. I mean, when we started, our marketing plan was to be the suburban health and wellness community store. So we do sell basically everything is hemp-derived cannabinoids.
Okay, got it. And tell us about the average customer of Serenity Organics. What's the average demographic?
40 to 60 affluent, living in suburbia. I like to call them soccer moms and dads and their parents.
Okay, 40 to 60, living in the suburbs, soccer moms and their parents.
Yes.
Okay, that's pretty good.
Yes.
Okay, that's every politician's demographic right there.
It's myself and my husband, basically.
Okay. And okay, so are the customers basically the people who probably live in the community as well?
Yes.
Okay, these
Yes.
are your neighbors?
Yes.
A lot of these are your neighbors?
Yes.
Okay. You know these people?
Yes.
You know their names?
Most of them, yes.
You know their families?
Yes.
Okay. These are one-off customers, repeat customers. Give the judge a sense of your interaction with your customer base.
The majority of our customers are repeat customers. One thing, because we had to open during COVID, when someone came in our store, we saw them again. And that really is been the best way we've grown the business is the repeat, and then our customers telling their friends and family and, basically everybody they know.
Okay. Well, I'm going to ask you a big question.
Yeah.
Okay.
Yes.
Why do these people come to you?
Because they trust.
I mean, there could be a number of reasons, right? Give us some of those reasons.
They trust us. We on day one, the first time they come in, we will walk the entire store. We've spent 2 hours with customers, 30 minutes with customers. We talk through the products. We explain the differences between hemp and marijuana. We have brochures in the store. We have signs in the store, and we educate them. They also come to us when they hear things in the news or something's coming up. They'll come in and find out what is going on. But education has always been, consumer safety and education have been from day one in our business plan, on our marketing plan.
Okay. So your neighbors that you know,
yes,
a lot of them you said, repeat customers, they
yes.
come in, they trust you, you educate them, they're coming in to buy your products.
Correct.
Okay. And you described the demographic as 40 to 60, soccer moms and their parents.
Correct.
Okay. Why your products though? Why is this demographic? Why are they coming in to purchase your products?
Because we have, in our opinion, we have the best products on the market. I do everything branded. I don't do anything private label. I wanted full transparency, so all of my customers can go in and research the brands, the company. And honestly, it's because they trust us, because we trust those products. We wouldn't carry something in the store if we hadn't fully vetted it, fully understood it, understand the company.
What kind of needs do these people have?
We hear, the pain, sleep, and anxiety are the three things we hear every single day. We do get, there's been a lot of menopause lately. We've heard that. Arthritis, PTSD. One of the bigger things recently is the alcohol. My generation, I don't like to, I like a glass of wine, but it doesn't agree with me so much anymore. So a lot of people have moved from alcohol into the drinks. So that is our biggest growing business.
Okay. So, if I understand your testimony correctly, it's people who have a variety of issues. I think you said pain, sleep, and anxiety.
Anxiety.
And then those who are trying to reduce alcohol consumption?
Correct.
Okay. You were present during Mr. Fuller's certainly very compelling testimony, weren't you?
Yes.
And very
Yes.
Provocatively explained the impact on the veterans community.
Yes.
Has that been your experience?
Yes.
Tell
Yes.
us about that.
Well, some of his exact words. I have a veteran and ex-Marine who.
Objection, Your Honor, to the extent this is going to get into hearsay.
I didn't ask anything about hearsay.
I haven't heard any hearsay yet, but you may object at that time if it comes up. I will ask you, Mr. Snell, if you could get a little closer to the microphone. I'm concerned my court reporter won't be able to hear you.
Okay. I apologize.
You can ask the question again.
I asked you about Mr. Fuller's testimony.
Yes.
And I asked you if that has been your experience.
Yes.
Could you tell the judge about that?
Of course. I have one of my customers in particular who shops every week. We had this conversation. He did resort to alcohol. He no longer drinks alcohol, and he specifically said, I'm a better husband, I'm a better father, I'm a better son. Said those words directly to me in my store.
Has that been your experience beyond this one customer in the focusing on the veteran community?
Yes, yes, yes. I have actually just yesterday. It's a husband and wife, retired veterans. They were in. They sent us a
Objection, hearsay.
All right, so I'm gonna have Mr. Snell give you the instruction on hearsay. And also, if you see any of the lawyers on this side stand up, I'm gonna ask you to pause so that I can hear their objection.
Okay.
Well, except in certain circumstances, you're not allowed to tell us what other people have told you.
Okay.
Okay. There's a hearsay which applies in limited circumstances. And so I'm going to ask you questions that hopefully don't get you into those areas.
Okay.
So you were saying you had an experience beyond this one customer or someone you learned that some other veteran had experienced a similar
Yes.
benefit of hemp products.
Yes.
Okay.
I have many veterans that shop our store.
Okay. Are you you and your husband and your store, Serenity Organics, are you guys good community members?
Yes, we are. We have sponsored many events in our subdivision. There is a fundraiser for scholarships for high school seniors coming up in a couple weeks. We have sponsored pet events, pet shelter events. We have also had, there are a bunch of schools in our community that have all come to the store and asked us for monetary sponsorships for different events, sports teams, drama club, the choir. So we definitely are a member of our community. We have partnered with fitness centers. We have we set up a table next to the police at that event. So we are definitely a member of the community. We partnered with HEB as well. So
you set up a table at a community event next to the police table?
Yes.
What was that event?
It was at a fitness place. It was a member appreciation event. So we were next to the Missouri City Police.
At a fitness expo?
Yes.
Okay.
Yes.
Do you have a good relationship with law enforcement?
We do. Yes, they do come into our store. One of the Missouri City policemen uses our store as to train recruits. So they come in and we kind of walk through the product and helps them train some of the new policemen.
Okay, you're telling Judge Lytle that sometimes the police come in and use your store to help train?
Yes, they do.
Okay. Let's talk about the rules that are subject of this litigation.
Yes.
So your licensing fee was how much?
$155.
Okay, and what's it gonna?
It will be $5,000.
Okay, is that a big deal to you?
It's a huge deal.
Okay.
Yes.
If the temporary injunction is not entered, and the fees go up to $5,000, what's it going to do to your business?
We would really contemplate having to close. I mean, some of these rules are going to be very, very difficult to sustain. So we would really seriously think about having to close the store.
if the temporary injunction is entered and the injunctive relief stays in place, is your business on an upward trajectory, level, down? Tell us.
It is. We were up double digits up until March 31st, and those 10 days we dropped 42%. So for the year we're up 10, but yes, we were a growing business. This has taken 6 years to grow because of the fact that we have been educating, and that's how we've grown the business. But yes, we would take a substantial hit if the injunction is not granted.
The business will take a
substantial hit.
Okay. A substantial hit to the extent that it may place the business in peril?
Yes. 100%.
Let's talk about not just the licensing fees. Let's talk about the cost of compliance, not just the economic cost of compliance. Okay, the administrative grind of compliance also.
Of course.
With respect to having to adhere to some of the rules that would be in effect, but for the TRO and hopefully the TI. Could you talk to the judge about the impact they would have on your business?
Yes.
If you were to have to adhere to those rules?
Yes. So we would have a couple options. I would have to work more hours. Again, I have two different jobs. Or we would have to hire someone, which obviously with a $5,000 fee plus some product going away, it just would not be sustainable. I mean, so it would put more pressure on my husband and I, or we would have to seek an employee to help with that.
What about products that you may have to remove from your shelves? Would that happen?
Yes.
If the rules were to
Yes, yes, it would be about 40% of the products we would have to remove from the shelves, and some of those would be the topicals, some of those would be the full spectrum CBD. I have pet treats. I have a pretty decent pet business as well, so there would be a lot of 40% of the products.
Would you talk to Judge Lytle about the impact or the confusion in the marketplace, if you would use those words, as a result of these rules, these that went into effect March 31st, 2026?
Confusion with the customers?
What have you experienced from your customer community with respect to these rules going into effect?
They're confused. They thought after the last year's legislative session that everything was good and we would be around and they would continue to be able to get the products that they need. And now they are thinking that we won't be around, and they're scared. I have also have had people in tears, and have they're like, what will we do? So there's a lot of confusion. There's a lot of people are afraid.
Okay. Mr. Fuller, in his compelling testimony, described his fear of what would happen in his community, his veteran community, should these rules not be enjoined. Do you share the same fear with respect to your community of customers?
Yes.
And these customers are your neighbors and friends?
Correct.
Do you have those fears with respect to your neighbors and friends?
Yes, correct.
Do you have the financial reserves to stay in business if these rules go into effect? And in your business experiences, the kind of financial impact that you said you thought it would?
I do not. I have, this was a startup business, so we've already put a lot of personal funds into that, but I would not have the reserves to keep it going for a long period of time.
What are your customers going to do if that happens?
That's a great question, and they ask me that every single day because they tell me they do not.
Yes, sustained. You maybe rephrase the question. Just that she can't move forward with that one.
You interact with your customers.
Yes.
You get a sense of what their state of mind is.
Yes.
What's the state of mind?
They're scared.
They're scared what's going to happen.
They are scared about their health and wellness if we were to close our store.
Man, are you scared for them?
100%.
Is that why you're here?
That is 100% why I'm here.
Pass the witness.
Ms. Thorburn, come on up. Yep, go ahead.
Allie Thorburn for the state defendants. Good afternoon.
Hi.
I just have a few questions for you.
Of course.
So I think you said that one of the reasons people come to your store is because they trust you.
Yes.
And they trust you to really explain to them what is happening in the products that you give them.
Correct.
And one really important thing for the customers to know is what's in the products, right?
Correct.
And so your shop does testing on the products?
So we don't do testing. We have, again, all of our products are branded, so all of our products are third-party tested before they get to us.
And so those products have a THC content?
Correct.
A THCA content?
Correct.
A CBD content?
Correct. They all, again, every product, from day one when we opened that store, they had to be third-party tested, and we had to have all that information.
So all of your products are already tested?
Correct.
And it's important that that information is on the label, right?
Yes.
You want people to know what's in it?
Yes.
And what those products can do?
Correct.
And how using them could affect their effect?
Correct.
And so you explain to your clients that if THCA is heated, it converts to THC at a rate of 87.7%.
I don't necessarily get into a conversation about THCA conversion. The conversations are, what is the difference between hemp and marijuana? What is the difference between CBD and THC? Those are the things that my customers know. I have a chart in the store that talks about all the benefits, but they are asking, what is the difference? Obviously, we have packages on the shelf, so what is the difference between the two? That's the conversation that we get into.
So you don't tell them that THCA converts to THC?
I don't tell them that. If they ask, if they read and they ask me about it, I will explain that part to them. But again, the conversations are hemp and marijuana and what is the difference.
You mentioned that the fees will really impact your business.
They will.
Your gross income for your business the fees are $5,000 a year?
Correct.
And your
They
gross,
will be.
They will be.
Yes, they are. Sorry. Yes.
Sorry, I don't want to speak over each other for the court reporter's benefit. Okay. So fees will be $5,000 for your business a year.
Correct.
And in 2025, your business grossed about $280,000 to about $300,000.
Correct.
But you're concerned that if these rules go into effect, you could lose up to 40% of that gross?
Correct.
And that's because hemp flower and THCA products are one of the two of your best-selling product categories.
So predominantly, I'm an edible store. The flower business in the last 2 or 3 months is up to about 30%. But there are a lot of full spectrum products, pet treats, topicals, broad spectrum CBD gummies that would have THCA in it.
And I want to focus on the flower. That's about 30% of your business, you say?
Uh-huh.
And that's meant to be burned?
I have customers that same thing as earlier testimony, they make tea, they cook with it, they make brownies with it.
Heated?
Some would heat it, yes. Yes, obviously if you make tea or brownies, you are heating it.
No further questions.
All right, thank you.
1 second.
Anything further, Mr. Snell?
1 second, Judge.
Okay.
I apologize. If I may, please have 1 second.
All right.
You were asked about conversations, you're asked by my esteemed colleague on the other side about conversations with your customers concerning the ingredients of your products. Remember that?
Mm-hmm.
Okay.
Yes.
Have you discussed with them are you asked by your customers about this total Delta-9 THC conversion rate?
Mr. Snell, the attorney's standing up behind you. Go ahead.
The question said it invokes hearsay.
She opened the door. She asked about these same things I'm asking about. Excuse me?
If I may respond, my questions directed her to discuss what she told them, not what they asked her.
That's ridiculous.
Her question, say that again?
My questions to the witness requested the witness to discuss and tell the court what she told people, so she was adopting those statements on the stand and they are not hearsay. This question specifically requests out-of-court statements by her customers, so I would maintain my objection to hearsay.
May I respond?
You may.
Hearsay includes what a witness on the stand says out of court, not just what other people say. And so she directly asked about hearsay, and I'm following up on those questions. She opened the door.
Well, she asked what she said.
And that's hearsay.
Well, she asked what she said. There was no objection to that. She answered that question. And so now you're saying that because she answered that question, you can ask her about what other customers said?
I'm asking
in her
about the
store?
same conversations. That's right.
No. That objection is sustained.
Okay. Have you explained to customers what this total Delta-9 THC conversion test is?
I have.
Okay. Is that in the context of being asked about what these new rules may require?
Yes, the conversation is that if the new testing of THCA that my pet treats we would no longer be able to carry the pet treats if the THCA converted to Delta-9 and became more than 0.3%. My pet treats or my topicals that people use for muscle, joint pain, arthritis would no longer be in the store.
Okay. Pet treats? That's one example of a product?
Yes.
Okay. Can you give us some others?
So topicals, CBD balms,
Okay.
full spectrum tinctures, full spectrum gummies, my sleep gummies with CBN, anything that's full spectrum, and then all of my except for 2 products, all of my CBD products are full spectrum, which means they would have THCA in them.
Okay. And these are products that the rules go into effect coming off your shelf?
Yes.
What's going to happen to that inventory?
I will have to destroy it.
Okay. And this is inventory you've invested in?
Yes.
You paid for it?
Yes.
Okay.
It will be obviously a loss.
And could you estimate the loss of what your inventory loss should you have to do that?
Let's see. $40,000.
Okay.
Something like that.
And what's your annual revenue right now?
About $280.
Okay, so
So 40 at cost.
I'm
So-
sorry, so repeat that.
So which part?
The last sentence. So 40.
40 at cost.
40 at cost.
Yes.
And what kind of loss in revenue would that represent? Because there'd be markup on that.
Correct. It would be 80 to 100,000.
Okay. Pass the witness, Judge.
All right. Anything further?
No, Your Honor.
All right. Thank you for your time. You're excused.